Good morning and welcome to the Public Service Commission of South Carolina for this morning's proceeding and docket number 2022-300-A. It is Tuesday, February 28th at 10 a.m. Let's take a roll call of commissioners. Present in the hearing room, we have Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston. With us virtually, we have Commissioner Irvin and Commissioner Justin Williams. We'll recognize our staff counsel, Sandra Mosler, for reading of the docket.
Thank you, Madam Chair. Good morning, commissioners and parties. We are here today for the proceeding in docket number 2022-300-A regarding practice and procedures for the Public Service Commission, Chapter 103, Article 8 of the South Carolina Code of State Regulations. All interested members of the public and the regulated community were invited to make oral or written comments on the proposed regulations at this public hearing before the Commission. The proceeding has been scheduled for today, February 28th of 2022 at 10 a.m. And Madam Chair, I believe all parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Ms. Moser. Let's take appearances. This morning, we have our Executive Director, Jocelyn Boyd, that will be making some statements about the proposed regulations. I also see we've got some parties listed. South Carolina Telephone Coalition.
Madam Chair, I'm Peg Fox. I'm here with Tracy Green today representing the South Carolina Telephone Coalition, and we're also representing Lockhart Power Company in this docket.
Thank you. And that was my next one, was Lockhart, so we'll note you for both. Piedmont Natural Gas Company.
Madam Chair, I'm Jason Richardson. Sorry.
I see you back there.
Jason Richardson representing Piedmont Natural Gas Company. Appreciate the opportunity to be here today. Thank you.
Thank you. Blue Granite Water Company.
Morning, Madam Chair. Lyle Trawick here on behalf of the company, and also with me is Zach Payne.
Thank you. Southwest Water Company. Not present yet. Duke Energy Carolinas and Duke Energy Progress.
Good morning, Madam Chair. Katie Brown. I'm here on behalf of Duke Energy Carolinas and Duke Energy Progress. Also here with me this morning is Frank Ellerby from Robinson Gray, Rachel Elliott, and Ken Smith.
Thank you. Is anyone from the South Carolina Department of Consumer Affairs? Dominion Energy, South Carolina.
Good morning, Chair Belzer. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina. And with me today is Belton Ziegler. He's our outside counsel from the firm of Womble Bond Dickinson.
Thank you. And South Carolina Office of Regulatory Staff.
Madam Chair, good morning. Nicole Given on behalf of the South Carolina Office of Regulatory Staff.
We kind of have you over in Siberia, it looks like.
I know.
Welcome, everyone. It's sometimes a challenge to do placement in the room. So, Council, I invite you today to speak from where you are most comfortable. It's very important to be at a microphone, though, so that we can get down everybody's comments, if you would. But want everyone to feel comfortable as they make comments or presentations today. Are there any preliminary matters yet before we begin? Hearing none. Ms. Boyd?
Good morning, Madam Chair. I'm Jocelyn Boyd, and I'm employed by the Public Service Commission. Before I begin my presentation regarding Commission staff's proposed changes to Article 8 of the Commission's regulations, I'd like to ask the Commission, or the Chair rather, to consider placing certain jurisdictional documents in the record. And I can proceed
That is
with
my
that.
preference. Is there any objection from anyone? Okay. Thank you, Ms. Boyd. If you'd proceed.
Yes, ma'am. I'm going to try to present these in chronological order. All right, so I will begin with the notice of drafting, and Ms. Adams is assisting me this morning and will provide the commissioners with copies of these documents and a copy to the court reporter. So the first group of documents that you will receive is these documents are posted on the docket management system, the PSC's docket management system. The watermark on the first document is September 8th, 2022. It is the notice of drafting that was filed with the Legislative Council. The second single-page document, it was posted also on September 8th, 2022, and is the official file stamp copy of the notice of drafting.
Is that a composite exhibit?
Yes, ma'am, please.
Okay. We will mark the notice of drafting and the stamped copy showing that it was filed with Legislative Council. Mark that as hearing exhibit 1 and receive that into evidence.
Give Ms. Adams a chance to. Okay. Okay, the next group of documents relates to the proposed regulation, Madam Chair. Commission staff posted a document that has a watermark in the middle of the page that reads draft. It is dated November 8th, 2022. And that was a draft of the proposed regulation, which is the next document you will find in the stack of documents you were just handed. The watermark on that, the second document, is November 10th, 2022, and it's the actual proposed regulation that was filed with the South Carolina Legislative Council. The next document you'll see in your hand
Is this a composite exhibit?
It is,
Okay.
yes, ma'am, please. The next document is watermarked November 15th, 2022. It was filed with the South Carolina Supreme Court on November 14th, 2022. The next two documents in your hand are verifications that the agency is required to conduct after we file the proposed regulations with the Legislative Council. So we have to go through and reread and proof our documents again and notify the Legislative Council if we have any corrections. So that's what you see. One is a document that is basically a clean version, which does not contain strikes or underlines, and the other one contains strikes and underlines.
And those two pages have a verification in the upper right corner with
Yes,
your
ma'am.
signature saying pending corrections?
That's correct.
Is that correct? So this is a composite exhibit of 5 documents? Is that correct?
Yes, ma'am.
Okay. Parties, if anyone has any questions or objections to these, please feel free to let me know. But that will be marked as composite exhibit number 2 and received into the record of this case. Or if anybody needs to see these, please let me know.
The next to the last group of documents that Ms. Adams will distribute to you includes the copies from the South Carolina State Register. The first document is the notice of drafting, and at the bottom of the page you'll see the name South Carolina State Register, Volume 46, Issue 9, September 23rd, 2022. The next document in your hand was also published in the South Carolina State Register on November 25th, 2022. It is the proposed regulation that was filed by the Public Service Commission staff. And then finally, on the back of the second document that you were just handed, you will see a link down at the bottom. It says, for the full text of this regulation, visit this site. So the third document that's in your hand that Ms. Adams just handed you is a copy of the document that can be found at the link at the bottom of the second document. The last page at the bottom, it says, for the full text of this regulation, click this link. So the third document contains the entire regulation, including the underlines and strike-throughs, the proposed changes.
And that third document, given the cover sheet on that shows agency name as Public Service Commission, statutory authority, and document number, that is printed from the legislative website. Is that correct? Okay, thank you. The state register notices and the draft regulation will be a composite exhibit marked as hearing exhibit number 3 and received into the record of this case. Anything further on the jurisdictional documents?
No, ma'am.
Questions from any party or objection? Hearing none, thank you.
Madam Chair, the document that Ms. Adams is now providing to you is actually a slide deck that was prepared by staff and prepared if you are okay with me presenting that at this time. And the slide deck is just these are highlights of changes, proposed changes to Article 8.
Just an overview of what's being asked today.
It's an overview
Okay.
of the staff's proposed regulations. That's correct.
All right. Any objection to Ms. Boyd presenting her slide deck with going over the revisions? Hearing none, Ms. Boyd, please proceed.
All right. Thank you, Madam Chair. Ms. Purvis, will you help me out? Thank you. So today, of course, is February 28th, and the chair began this proceeding this morning at 10 o'clock a.m. On page 2 of the slide deck, you'll find just a reference to why the commission staff started this process in the fall of 2020. And we opened a docket 2020-247A to conduct workshops and just to hear from interested stakeholders about the state of the commission's current regulations. Every state agency is required to review their regulation or its regulations every 5 years. This is just some other information that I just reviewed with you regarding the notice of drafting and also the proposed regulation. Both of those documents included a public comment period. The next page contains basically what you will find in any document that references the proposed regulations that are before the commission today. And this is just a list of those regulation numbers and the subject matter related to that regulation. This page, the next page also includes the regulation number and the subject matter. Okay. Regulation 103-805 relates to representation, and staff is proposing 2 changes to this regulation. One, which will require individuals who represent himself or herself to comply with Regulation 103-817.1, which relates to e-filing and e-service of commission documents. The next change that you will see, it relates to references in 103-805 to Certificate of Public Convenience and Necessity and to Fit, Willing, and Able, or FWA. And staff removed those references because of Act 2014 of 2022, which, as you know, changed the structure of how transportation applications are processed at the commission. And more details regarding what I just described can be found in the now amended South Carolina Code annotated section 58-3-210. That basically informs the commission as to how it is to process applications for motor carrier certificates, from charter buses to Class E household good movers. The next page you'll find, the next slide rather, is 103-816. And it's regarding written correspondence to the commission. There's some outdated information. We have not, the agency has not had a post office drawer for several years now. So we need to delete reference to that. And just in case the agency moves, our lease will be up here in a couple of years. It's possible the agency will move its location, and it maybe not the next term, but the term after that. So we want to make sure the public is aware of where we're located. It can best do that through visiting our website. So we're suggesting to amend that regulation to refer the public to our website for the commission's physical location. Regulation 103-817 relates to proceedings, and what we want to do here, this change relates to, I think, some outdated terminology. Certificate of mailing, or proof of mailing, we'd like to update that language to read certificate of service or proof of service. And also, as you are aware, we have authority, the clerk's office does now, to serve certain documents electronically. And so those documents don't have to necessarily be mailed. So we're replacing the word mail, M-A-I-L, with furnish. The next regulation, 103-817.1, relates to e-filing and e-service of commission documents. And we've provided more detail regarding certain types of filings that initiate dockets. So you'll see, instead of just stating summons and complaint, we've replaced that language in one area with the words application, petition, complaint, and rule to show cause. Those basically relate to documents that initiate a docket. And E2 of 103-817.1, instead of including limiting language, we just basically strike summons and complaint or other and just state plainly any filing that initiates a case. 103-823 relates to the Commission's regulation on applications. And this is probably, this and maybe is one of 3 regulations that contains some pretty significant substantive changes today. So the first part of this regulation under 103-823A3, there's some new language that includes filing requirements for electric, gas, water, and wastewater utility rate applications. There are some instructions that state that these new schedules will be filed in Microsoft Excel format with all formulas intact. The language also states that the schedules will be filed on schedules, forms, templates that are approved by the Commission. One point I want to make, I'll show you, well, you will find in the section, this section previously read, what you will find under the electrical and gas utility rate application section for utilities that have 100,000 customers, fewer than 100,000 customers. That was basically the substance of this regulation, and that is the substance of this regulation. Staff proposes to include all information related to any electric, gas, wastewater, or water rate application in one area, under one regulation of the Commission's regulations. Hence, you will find schedules that pertain to electric utilities, gas utilities, water, and wastewater utilities now under 103-823. You'll also find at the end of the schedules, Commissioners, the requirement that when a rate application is filed, that the utility will include or must include its direct testimony. And you'll also see where there's some other business entities listed, limited liability companies not listed, and so staff added that language. We also added some language that pleadings and testimony filed with the Commission must be in searchable PDF format. Now, staff participated in workshops in 2021, 2022, and we've also reviewed comments that were filed by interested stakeholders in docket 2022-300A. The docket's before the Commission today. We have some of the comments staff agrees with. We understand the Commissioners have the final decision, but we wanted to share our thoughts with you. Staff is not opposed as it relates to the minimum filing requirements for those forms, templates, schedules, whatever terminology you want to use. That if the Commission decides to review and approve forms that are filed by utilities for approval. So the schedules, the titles of the schedules are listed in the documents we provided to you, but we are not, staff of course is not opposed and supports utilities filing their own templates with the Commission for your approval. Staff does have, if you get to that point, staff has templates that is prepared to present should the Commissioners ask, but want to make note of that. Also, there was another stakeholder who asked, made a suggestion that if it was the intent of the Commission staff to include information related to excess deferred income taxes in the deferred tax adjustment, that we actually delete the schedule. It's currently under Section C11 in the electric gas utility rate filings, to move that from the Section C to Section B and rename that schedule to excess deferred income tax, and staff supports that comment. The next schedule, another stakeholder asked.
Ms. Boyd.
Yes, ma'am.
Could you go back to the previous slide?
Sure.
That B15 would be a new schedule under B, is that correct?
Right.
Okay.
It does not currently exist.
Okay, thank you.
Mm-hmm. All right, and we received another comment regarding the minimum filing requirements for wastewater utilities, currently Schedule A13 under wastewater utilities. just reads most recent letter of approval, including percentage of capacity from the South Carolina Department of Health and Environmental Control. That language is a little inconsistent with the water utility schedule A13 for approval of an increase in existing rates or modification of existing rates. So we've added the language, or we support the comment and propose adding at the end of the wastewater schedule A13, the language dated not more than 6 months prior to date of application, to make those two regulations consistent. When I say those two, I mean the water and wastewater utility regulations consistent. There was another proposal, Madam Chair. I say a proposal, it could have been more than one, related to cost of service studies. These are not currently in the Commission's regulations, and staff supports amending schedules E1 for the electric and gas utilities, A 9.5 for wastewater utilities, and A 9.5 for water utilities, so that cost of service studies conducted not more than 5 years instead of 3 years prior to the company's filing for a rate adjustment be included in the application. So we support the 3 instead of the 5. 3 years, we support the 5 years versus the 3 years. Okay, moving on to Regulation 103-830, which relates to filing and service of pleadings. We just updated this language to replace the word MAIL with furnish and the word MAILED with the word furnished. Regulation 103-830, service between parties of record. I recall in this regulation, and this was way before the Commission had electronic service of orders and e-filing in the manner it exists today. And parties are required under the current regulation to basically file or create a written document which memorializes the parties' agreements to be served electronically through email or electronic service, to be served filings in a docket electronically. But in order for that to happen, there must be a written document memorializing the parties' consent. So to update that, because as you know, just about everything takes place electronically nowadays. This staff's proposal would require for any party in a docket that those parties, those persons, will agree to service of filings through email or electronic service, unless a party doesn't have the capacity to receive service in that manner. Okay, the next one, Regulation 103-833, and that pertains to written interrogatories and requests for production of documents and things. The initial proposal includes a change where working papers, the phrase working papers is deleted, and it is replaced by the phrase attorney work product. The proposed changes also allow the Commission, provide that the Commission can shorten the time period for written interrogatories and for production of documents and things, request for production of documents and things. The regulation currently reads that the Commission can already extend the time period, but it doesn't include the phrase or the word shorten. So we've added the word shorten to that, where the Commission can extend or shorten the time frames for that type of discovery. And then we also include the phrase limited liability company, as certain other business entities are mentioned in 103-833C.
Ms. Boyd, may I ask a question?
Yes, ma'am.
On the first bullet there, to delete working papers and include attorney work product, was that supposed to be, based on comments, a deletion, or was there to add something there?
I haven't gotten to that slide yet.
Okay, thank you. Sorry.
No problem, Madam Chair, you're on it. All right, so this is staff's review of public comments. And after reviewing some staff's review of comments that were filed in docket 2022-300A, staff is in support of the change that you see on this slide, where the language would read, or is hearing preparation work papers, that's current language, or attorney work product, that would be the new language, prepared for the pending proceeding and or in anticipation of litigation. So staff supports that change. It's made by a stakeholder.
Chair
Okay.
Pelzer,
Commissioner Karen Lee Williams.
thank you. Director Boyd, if you do not reference a request made by one of the interveners, does that mean staff does not support that change?
I think staff wants to hear more from the stakeholders who are here today. So
Okay.
it does not mean that we don't support. We just feel we need more information.
Would it be appropriate for me to ask you about a specific one that you haven't mentioned?
Sure.
So in B, there was the suggestion that limited liability company be added in B. It's already added in C.
Oh, okay.
It
Yes,
seems-
yes, ma'am. Staff, I can tell you we support that.
Okay, thank you.
You're welcome. Thank you, Ms. Purvis. Okay, we're going to move now to, 103-835. This relates to other discovery procedures. And this regulation basically states now that any discovery procedure that's not covered by the Commission's regulations is governed by the South Carolina Rules of Civil Procedure. We are proposing to add language where the Commission will be able to entertain proposed modifications to discovery procedures and schedules. Additional language includes all discovery being served on all parties if the parties request copies of the discovery, but they must all abide by confidential and or proprietary materials by signing a non-disclosure agreement or abiding by a protective order. And then we also included language that it's a statute that references documents that are provided to the Office of Regulatory Staff and making sure that those protections remain in place. The next slide relates to how our hearings are set, and this proposed change would authorize the Commission to conduct its proceedings virtually or by other remote means. And I've just included here a statute which our agency, where we file reports annually with the House Ways and Means Committee and with the Senate Finance Committee regarding the Commission's administrative hearings, where those hearings are conducted through video conferencing capabilities. And just wanted to make the Commission, I'm sure you're aware of it, but I just wanted to include that in the slide deck, that we're authorized to conduct administrative hearings using video conferencing capabilities. We have to show that there are cost savings for doing so, but just wanted to include that statute for your reference. All right, 103-841, presiding officer. Now, Commissioners, you're familiar with our hearing examiner process. You actually appoint hearing examiners at the Commission business meetings, and then those examiners hear different types of cases. They hear cases where a company would like to operate in South Carolina, but they need a certificate of public convenience and necessity to, for example, to provide telecommunications services. Or you might appoint a hearing examiner for the attorney to hear an individual customer's complaint regarding a jurisdictional utility. A part of that process includes your appointed staff attorney conducting a hearing, administering oaths, receiving evidence, and also providing a proposed report of the hearing examiner's findings and conclusions to the parties in the case. We support this process moving along a little bit faster, and that would include the deletion of the presiding officer's report. So basically what will happen from beginning to end is a filing is made with the Commission that basically initiates a docket, right? A complaint or a certificate of public convenience and necessity application. And the Commission would then, if it deems necessary, if it wants to, appoint a hearing examiner during a Commission business meeting. Staff in the meantime, it's probably, if it's an individual complaint, it's probably already sent a scheduling notice to the complainant, to the utility, to the Office of Regulatory Staff, and a copy to the Department of Consumer Affairs. So that process is already working. And then when the hearing is held, sometimes it's held by video conferencing, sometimes in our law library or other location at the commission. The attorney hearing examiner entertains the case, receives evidence. Then, under the new proposal, instead of the hearing examiner preparing a report, the hearing examiner will basically gather the hearing examiner's findings and provide their findings to the commission. And then we will place that item on the commission's agenda for your review and disposal. Okay? Regulation 103-845. This is our pre-filed testimony regulation, and I know that you're aware there's a statute under Chapter 3 of the Commission's Title 58 that relates to testimony in hearings before the Commission. So this regulation covers. We're authorized to create this regulation basically under that statute. So some of the changes staff is proposing is that all exhibits that are filed with the commission must be readable and legible, no matter the size. That copies of testimony must be filed as prescribed by the commission. And that certain testimony be filed within 2 weeks with the commission if certain action takes place. If a notice of filing, a notice of hearing is issued or published by the clerk's office, then within 2 weeks of that notice being published, direct testimony must be filed. Now, there are exceptions that are included in the last sentence, as you'll see in 103-845. Those exceptions include individuals filing a formal complaint, appearing on his or her own behalf, fuel adjustment, and purchase gas adjustment cases. Regulation 103-848 relates to exhibits, and basically you see this similar language. All exhibits, no matter the size, must be readable and legible. The next one, 103-852, service of orders. So what happens now, we have the statutory authority, we being the commission, to electronically serve the commission's orders on legal representatives and parties in a case. And the clerk's office follows that information pretty closely. We track when a representative accepts service, when the representative does not accept service. And then if the representative does not accept service, the commission expends funds to send that order by certified mail to the representative. And staff would like to use that money in a different way, a more meaningful way, especially if the representative is familiar with our e-service system, familiar with our e-filing system. That's labor because we're having to monitor. Staff is monitoring whether or not a representative has accepted service. And there's additional labor as it relates to preparing the certified mail. And then there are costs related to that certified mail for the agency. So staff is proposing to add language to 103-852, which basically says, all parties of record who electronically file documents through the docket management system are served a commission order immediately when the clerk's office electronically enters the order on the docket management system.
Chair Belzer.
Commissioner Williams.
Thank you. Director Boyd, I noticed that this is all parties of record. Would it make any sense does that include attorneys? Should that be expanded any?
I think that's a great idea, Commissioner Williams.
Okay.
How would you propose us adding, would that be a proposal to add including attorneys of record?
That sounds, all parties of record, including attorneys of record?
Yes, ma'am. Or legal representatives, maybe attorneys of record and or legal representatives. I think that's a great idea.
Okay, thank you.
Ms. Boyd.
Yes, ma'am.
That language does not require the attorneys to accept the order electronically, does it?
It does not. No, ma'am.
I'm just concerned that it's not strong enough. It just seems that there are certain attorneys that never seem to accept the electronic filing. I mean, I can understand people that don't practice here regularly, but when it's people that practice regularly and they don't accept, it just seems like an added expense. I don't know whether they don't understand the system or whether they're trying to game the number of days, but something's going on when it's people that practice here regularly
Yes,
and
ma'am.
won't accept. So, and I don't know the process. If this may have to come up with discussion with the parties that are here. Can we strengthen the language? I know we can amend things, but can we strengthen the language to require the parties to accept if they have the electronic capability? Can we require them to accept it electronically?
Okay, so I'm thinking about this practically. If you require them, are we going to be able to rule them in?
I don't
The
know.
reason I say that, Madam Chair, is I'm trying to think of what can we do if they don't. If they don't,
I understand. I just it's just an issue.
yes, ma'am.
So we may have some comments from the parties that
Yes,
are
ma'am.
here. Thank
Yes,
you.
Yes, ma'am. Thank you. Thank you, Ms.
Madam
Brooks.
Chair.
Vice Chair Powers?
Ms. Boyd,
Yes, sir.
when you post something on DMS, like an order, aren't the attorneys notified by email or something that a post has been made?
Yes, sir. They're notified and they should receive, they should have an additional notification in their profile because anyone who is subscribed to the e-filing system will have a profile. So they should be able to access the same information. If they miss the email, it should be listed in their profile.
And getting the email should direct them to go look at the order,
Yes, sir.
should it not?
Yes, sir.
Thank you, ma'am.
But doesn't that email have a link where they have to click to actually confirm service?
It does.
I mean, they can look at the order without confirming service,
They
correct?
can.
That's the concern I have,
Yes, ma'am.
is because the system sends an email for
It
what,
sends an email, and I think they
3
have a couple
days?
of options. Yes, we do send the system, if the representative does not accept service, then after 24 hours, another email is sent. And then after 48 hours, one last email is sent asking that service be confirmed.
And I can understand somebody missing, if an order goes out on a Friday and they're missing an email on Friday and then the next one goes on Saturday and
Yes, ma'am.
Sunday. I mean, I
Yes,
can
ma'am.
understand that, but when it's repeatedly, that's what I don't understand.
Yes, ma'am.
And even if an order went out on Friday and there were 3 emails that went out before Monday, when somebody got to the office the next week, they could still click on that
Yes.
link and accept service,
That's
right?
right. That's correct.
Okay. Thank you.
You're welcome. Okay. Next to the last proposed regulation change is 103-853, finality of decision. And we've just added the phrase electronic service so that the regulation states commission orders shall take effect and become operative when served by electronic service, registered or certified mail, so on and so forth. And then finally, Regulation 103-855. This is in reference to that short story I was telling you about our hearing examiner process. This change deletes Regulation 103-855 because there'd no longer be a need for a presiding officer's proposed report. And that's all I have. If you have questions, I'm here to take them, entertain them.
Parties, at this point, before we get into comments that anybody may have, does anybody have any questions for Ms. Boyd that they wish to ask? Hearing none. Commissioners, any questions for Ms. Boyd? Commissioner Carol Lee, I'm sorry, did I miss somebody? Commissioner Carol Lee Williams.
Thank you, Chair Belzer. Director Boyd, on 103-823, you referenced that staff had templates that you would be happy to share with us.
Yes, ma'am.
I don't want to open a Pandora's box, but I don't want to not look at something that staff has prepared. So
Okay. Well, we did not, of course, we did not include these templates in the regulations. First and foremost, you understand the regulation process. And if the commission needs to change the substance of those forms at any time, I just don't see how, I don't see where that's efficient, expedient. Whereas you have forms now, our transportation forms that are on your website. We have a complaint form. When the commission needs to modify those type forms, it can do so at a next business meeting as long as you give 24 hours notice. But I have a copy, and we have a document camera here. So I can share.
Is the recommendation from staff that the templates would be approved by commission order and not by regulation in case
Right.
things needed to be changed?
That's correct.
Thank you for the clarification.
That's staff's opinion. Yes, ma'am.
Okay. And I understand there may be other opinions. We'll get back to that.
Okay.
Any further questions, commissioners, for Ms. Boyd at this time? Okay. All right. Let's see how we can do this. Parties, I'm gonna seek your guidance on some of this, and I might just say, I think I know where the most discussion is going to be here. So I think just to be clear on where we are on some things, would you object if we just go through as Ms. Boyd just did a high level, if we go through to determine whether anybody has any comments or on each suggested change? And I think the minimum filing requirements is probably going to take the most or start the most discussion. I could be wrong on that, and maybe we keep that one till the end and go through all the others just to see if there are any suggestions or concerns with the ones that are listed. Does that suit? We don't get to be a democracy here very much, so this might be your only chance.
Madam Chair,
Ms. Fox?
we did have, the South Carolina Telephone Coalition did have one comment that wasn't covered in the presentation by staff because it was it's an issue with one of the regulations that we didn't find out about until the end of December, and so it wasn't discussed in the workshops. So if it would be appropriate, I'd like to maybe raise that because it's additional and doesn't relate.
It's in the 800s, right?
Yes.
Yes. I mean, we can raise that when we get to it if we'll just go through them. Is that okay? You can point it out. You want to do it now?
So it'll be, I can do it now or I can do it when we get to it in the middle of wherever we are, but it's not covered in in any of the
Let's
staff
do that
comments.
if you don't mind.
Okay, that's fine. Thank you.
Okay. Ms. Boyd, I'm going to ask that you guide us through the individual changes so that we can
Yes, ma'am.
just
No problem.
get comments from the parties. Parties, I'm going to ask that you get my attention if you have something to say on these. I think we
Madam
can
Chair.
conduct ourselves pretty quickly through this.
Madam Chair, the first regulation is 103-805, representation.
Any comments on the proposed change to 103-805C on representation? Okay, hearing none.
The next regulation, Madam Chair, is 103-816.
I'm sorry, that was one section, and then we had one E5 and E6, removing certificate of public convenience and necessity from E5 and striking FWA from E6. Okay, no comments? Ms. Boyd, go ahead.
Okay. The next is 103-816, written correspondence.
That's deleting the commission's address as it's stated and the post office box, which is no longer, and directing people to the website. Any comments? Okay.
Okay. The next regulation, Madam Chair, is 103-817, proceedings.
This is changing mailing to service in 3A and 3B, I believe. And, excuse me, B2 as well. Any comments? Concerns? Okay.
Okay, the next is 103-817.1, e-filing and e-service.
Any comments? Okay. And Ms. Fox, you jump in whenever we get to the one you're talking about.
Okay. Next, Madam Chair, do you want me to skip 823 for right now? That's applications, or you were?
Yes, I
Okay.
think we'll skip 823 for the moment.
For right now. Okay, the next is 103-830, filing and service of pleadings.
Okay.
Okay.
Filing and service of pleadings. Okay.
Yes, ma'am.
Mr. Torini.
This may be more appropriate when we deal with the service of orders, but I would turn that on. Okay. This may be, first of all, I want to apologize. Obviously, I had a calendar mix up today, but
Glad to have you here.
thank you. But this may, I don't know if this is more appropriate at a later stage in the proceedings, but I may be one of those delinquent acceptors.
I hadn't noticed you.
From time to time, but I'll tell myself. But perhaps one of the things to do with the e-service would be not to require confirmation of service of pleadings. Like, for instance, in circuit court, when we file pleadings or people file motions, we're not required to actively confirm receipt.
I don't think that happens on pleadings, does it?
It does,
It
Madam
does.
Chair. Well, it does if it is, for example, emails or a document that was generated internally. If it's not,
If Mr. Torini files a motion in one of his cases, does one of the other attorneys have to click to accept it?
they shouldn't anymore. They should receive a notice of electronic filing.
I believe, well, I may stand corrected, but it just, my only point would be the less you got to confirm, the easier it is to pay attention to what you really should confirm. So I'll leave it at that.
Well, Mr. Torini, you raise an issue. I mean, it's one thing with the pleadings and documents that are going back, that are being served between the parties. I'm concerned about not accepting a commission order.
And again, what I'm trying to narrow it down to is just that.
Right.
And also, if the emails didn't arrive if we just blacked out weekends, that also might help.
I know that's because somebody could be on vacation and out of the office for several days, and I understand that. What I've noticed are kind of just never accepting the order. That's my concern.
Yes, ma'am.
And that adds up when
Right.
there's multiple attorneys on, and we're having to serve each one of them. So, okay.
Chair Belzer.
Yes, Mr. Green.
Tracy Green for Lockhart Power. I'd like to echo Mr. Torini's comments as well. In circuit court, I don't ever have to acknowledge anything. I have not always been good about, especially if it's a tangential matter to what I'm really in the matter for. I'm not good about accepting it. But on circuit court, other than the initial pleading, I don't think I have to accept anything. I have to keep an email address on file, and that's presumed service on me. And that at that point, it's my problem if I don't take action.
Even an order from the court, you don't have to click on and accept service.
I believe that is correct, Chair. Yes, I don't have to click on anything or accept it.
And it's only sent one time.
It's only sent one time. That is correct. So that is what I'm used to.
Okay.
Now, I would not object to you sending it a second time.
Charlie says I've gone too far now. Thank you, Chair.
Thank you. I appreciate that information. Mr. Trawick.
Madam Chair, if I might, Lyle Trawick on behalf of Blue Granite. I would also note that is the practice in federal court too. So pretty much any attorney in the bar is used to this electronic service and receiving orders. And again, as somebody just indicated, if they don't respond in time, that's our problem.
Okay. So if you are served an order on Friday and you're on vacation through the next week, unless you've authorized somebody in your office to check on those things, you're just going to be behind the 8 ball on number of days that you may have to do something?
That's right.
Okay. Interesting. It's been a while since I've practiced in circuit court, let's put it that way. All right.
Okay, Madam Chair, we just finished, I think.
Let me
oh,
ask a question.
Yes, ma'am.
I know that we can take comments here and amend or change the proposed regulations. Is that, or that's my understanding. I just want confirmation on that.
Yeah, that's.
Because if something goes way far afield, we would have to renotice. But what is that something that we could amend in this proceeding without having to renotice?
Are you referring to how the service of orders, for
Yes,
example?
the
Yeah,
language
no, I
of
think
that reg.
I think that you can. You think you
Based
can
on
consider
those?
the comments? Yes, ma'am.
And that language you're referring to, and I hate to say this, but is that it contained in the rules of civil procedure or federal court rules? Probably.
In circuit court, there is a standing order from the Supreme Court on e-service and using the e-filing system. And I think it's contained, well, I know service is contained and is addressed in that order.
Okay. A standing order of the Supreme Court.
Yes, ma'am.
Thank you, Mr. Trini.
And Madam Chair, I'm referring to, I think that South Carolina Code annotated section 1-23-111C. This talks about, this section refers to what the presiding official can do as it relates to suggested modifications.
Oral submissions.
Yes, ma'am. So I think maybe that will allow you to, well, the APA already allows you to entertain written and/or oral comments for today's rulemaking. But I think this relates to what the action you can take based on the comments that you received today.
Okay.
And I think that you can use those comments to modify staff's proposed changes.
Thank you. Thank you all for those comments.
All right, Madam Chair, if you're ready to move on, I think I just read 103-830. I think that's where we
Dot
were.
one, yes, ma'am.
Okay, dot one. All right, then the next one is 103-833.
Madam Chair, excuse me,
Oh.
sorry, Ms. Boyd. This is where I
Okay.
have something on 831
All right.
that was not covered in these comments.
Oh,
or-
831. Okay, it's not
Yeah,
in.
It deals with computation of time. Would it be all right for me to speak to that now?
Yes, ma'am. Hang on a second. It's not in our packet, so let me find
Well, Madam
it.
Chair, and I can also place it on the document camera while Ms. Fox is reading it. I have my code in here.
That's good if you could do that.
You said 831.
It's in the main volume, I think. It's in the main volume, not in the supplement.
Okay. Is that okay, Ms. Purvis? Okay. Let me see. Think I-
Is it in there?
It's this part, Ms.
Those are the
Purvis.
comments, your notes.
Thank you.
At the top. Can you slide it down a little bit, Ms. Boyd?
Yes,
There
ma'am.
we
I
go.
sure can. How's that? There we go. Is that better? Make it a little bit larger, Ms.
I
Purvis?
think we can read that.
Okay.
It's on the screen in front of us if the
Yes, ma'am.
audience can read it. Ms. Fox?
Okay, so this is the rule that deals with computation of time, and it provides that generally the computation of time is governed by Rule 6 of the South Carolina Rules of Civil Procedure, which is fine. But then there's a sentence that we didn't notice until late December that says the provisions of Regulation 103-831 do not apply to petitions for rehearing or reconsideration. And the reason that's an issue is because Rule 6 has the effect of law. The South Carolina Rules of Civil Procedure were promulgated by the Supreme Court under constitutional authority, and they were adopted by the General Assembly in 1985 in Act 100. And when they adopted those, they repealed the statutes and replaced them with the Rules of Civil Procedure. So they have the effect of statutes. And in Act 105, Section 3, the General Assembly stated, in event of conflict between any provisions of the South Carolina Rules of Civil Procedure and any other statutory provisions as to practice and procedure not repealed in this act, the provisions of the rules shall control. And so I think there's a clear intent by the General Assembly to have the computation of time rule 6 apply. And so where that leaves us is there's a PSC regulation that says it doesn't apply to petitions for rehearing and reconsideration, which can cause confusion. Because when we looked at that, we had a situation in late December where an order was issued. We had 10 days to file a petition for reconsideration, and 7 of those days were holidays or weekends. But worse than that, the time ran on Sunday, January 1st, with Monday being a holiday, which we should have gotten until Tuesday, and we didn't. And it's not that we're complaining that we didn't have enough time. We do what we need to do. But the concern was that some people were looking at that and saying we had to file on Friday, the 30th. Yeah, December 30th, and some were saying, no, we have until Tuesday. And so anytime you have confusion with a regulation, that's just not a good thing. And so we would just ask that the sentence that says the provisions of Regulation 103-831 do not apply to petitions for rehearing or reconsideration, we would ask that that be struck, just for certainty and clarity going forward, so that everybody's playing by the same understanding of what that regulation means and when things are due. Because the last thing we want is for people to be in the Supreme Court arguing over whether, state law supersedes this PSC regulation and when the actual due date was. So that's the concern that we have, and we apologize. We participated in all of the shareholder meetings, and we really appreciate that collaborative process and the staff's, courtesy and all the hard work they've put in. And we apologize for not noticing that sooner, but it really, that sort of the week before, between Christmas and New Year's, kind of highlighted this for us, and so we realized that was an issue.
Point taken. Thank you. I'm just trying to think this through. I don't know that the computation of time under Rule 6 it's really not changing anything. It's really what you're asking for would just clarify, because this seems to be a unique situation that may have hit y'all in December, but it illustrates the problem, the potential problem. Is that correct?
Yes, that's right. Yes.
Okay. And your request is in 831 just to strike the last sentence.
That's correct, Madam Chair.
Okay. Ms. Boyd, would you make note of that?
Yes, ma'am, I have.
I know that, does anyone else have any comment, or any other party have any comment on that? I'm trying to think how this might have come about, and the only thing that pops into my head is that because the statutes governing petitions for rehearing, and I think they all say rehearing, I don't know that they say reconsideration, but that's how we all refer to them, I think. But since they do have those definite timeframes in there, I think that's probably why that sentence was in there, although that's just a guess on my part.
Yeah, I thought that too, Chairman Belser, but the computation of time in Rule 6 does talk about in computing any period of time prescribed or allowed by these rules, by order of court, or by any applicable statute. So I think it's more general.
Right. I just don't know why that was put there, except that it was of course it is a jurisdictional issue of filing within the correct time frame, but thank you for bringing that to our attention.
Thank you.
Okay, Madam Chair, 103-833, written interrogatories and requests for production of documents and things.
This is striking. Okay, there was a proposal, and then there was an amendment to the proposal, right?
Yes, ma'am, and I can go to that right quick. So our amendment appears, Ms. Purvis, if you don't mind displaying that.
And staff agreed with the proposal that was made by one of the parties.
Yes, ma'am.
Okay.
which would leave work papers and then add attorney work product and the language or in anticipation of litigation.
Okay. Any comments from the parties on that edit, that proposed change?
Chair Belzer,
Mr. Green.
thank you, Lockhart Powell. I think we had proposed that change that staff has agreed with. We were just concerned that the language is drafted was narrowing it a bit more than we thought was intended, and so we had just done that. So we absolutely agree with the amendment proposed by staff.
Well, in the amendment with the an anticipated litigation, that could reflect litigation not here at the commission, could it not?
That's right, Chair Belzer.
Okay.
That's right.
Okay. Thank you.
Which we think is consistent with how the rule is applied, and just trying to make sure that protection is
Yes, sir.
consistent with general law.
Yes, sir.
Thank you.
Thank you. And
Madam
then I
Chair?
think there was an is that Commissioner Irvin? Who was that?
I think that was me.
Oh, I'm sorry, Mr. Torini. I just heard a voice.
I think we suggested this at one of the shareholder meetings, or stakeholder meetings, shareholder. Is there really a need to file discovery with the commission since the answers aren't filed? Is there really a need to file discovery requests on DMS because the answers aren't filed? It's not consistent with state practice. I'm just not sure what the value is of filing the discovery requests on DMS.
I just think it alerts the parties, does it not?
Well, we serve the parties typically would say, send us whatever you send anyone else anyway. That's our initial discovery request. But I suppose you're right if someone didn't do that. I'm just asking, it's not a big deal. I mean, we certainly don't have any problems doing it.
All right. Thank you. And let's see, there were some
Chair
other...
Belzer,
Yes, ma'am, Ms. Brown.
we had filed comments on this regulation supporting Lockhart's proposal to.
I'm sorry, did you say did or did not?
We did file comments supporting Lockhart's changes, and it looks like those changes are the changes that commission staff has proposed, and we support those changes.
Thank you. Okay, Ms.
You ready? Yes, ma'am. The next regulation is 103-835, other discovery procedures.
Any comments or concerns on 835? Ms. Boyd?
All right. 103-836, how hearings are set.
Any comments or concerns on 836?
103-841, presiding officer.
Any comments or concerns? Thank you.
103-845, witnesses.
Any comments or concerns?
Madam Chair,
Mr. Ziegler.
Belton Ziegler on behalf of Dominion. Dominion does have one small suggested change to 845C, and it relates to the fact that there are some filings that fall into a gray area where you're not sure whether there will be a hearing or not. And right now, the regulation reads that that pre-filed testimony shall be required either with the application or within 2 weeks of the commission staff issuing a notice of filing, notice of hearing, or notice of filing and hearing. The notice of filing could be issued even if no hearing is going to take place. So you'd be filing pre-filed testimony for a hearing that really may not happen. So our suggestion would be to delete the notice of filing, keep notice of hearing and notice of filing and hearing, so that once it is decided that there is going to be a hearing, that would trigger the filing deadline for pre-filed testimony.
And under what you are recommending, if a notice of filing was filed and later a notice of hearing was, or a hearing was determined to be needed, a notice of hearing would be issued and the testimony would be filed within.
That's correct. Or you could have a situation where you weren't sure whether the staff and the commission would want a hearing even before the notice of filing was put forward. So it could be that you get the notice of hearing at the beginning. So that would be the suggestion.
Okay. Thank you, Mr. Ziegler. Any comments? Any further comments on that?
Madam Chair,
Ms. Brown?
Katie Brown, on behalf of DEC and DEP, I believe we agree with the suggestion made by Dominion's Council to delete the reference to, I guess, just notice of hearing. But
Notice of filing.
notice of filing. I apologize. I've got too much going on over here. I think the remaining issue for us is that 2 weeks in, a complicated matter is very little time for the companies to identify a witness. And I'm speaking about cases in which the companies or utility is not expecting to file testimony, identifying a witness, drafting, reviewing, editing testimony and filing with the commission in 2 weeks is, that's a really compressed time frame. I know that there is it looks like there's an exception built into the rule unless the commission shall otherwise order. So maybe that covers us there, but I think that the 2 weeks is, that's a really compressed time frame where the parties are not anticipating filing testimony.
Okay.
Madam Chair,
Commissioner Caston?
and what should it be? Is there a suggestion, or, I mean, I'm trying to follow everything everyone's saying and understand it well. And you're saying 2 weeks is never good, or it's sometimes not good.
I would suggest two things, Commissioner Caston, Belton Ziegler again. 4 weeks would give you some lead time to find someone and get through the process, because in a large company, not only do you have to determine the witness, but there's a pretty elaborate review process that has to take place before filing. The other point is that if you were to understand that the commission can extend that deadline, you need 2 weeks isn't time enough for the commission to actually have something on their business agenda and get the extension approved. So you'd be, in effect, not able to rely on that extension coming. You'd be in such a tight time frame, you might not get the extension until a day before the filing deadline. So you'd have to go through that process one way or the other.
Okay.
Could we not rely on standing hearing officer directives to grant extensions if upon good cause?
That would be a helpful way to go, absolutely.
I mean, I think we're trying to look at some of these areas where there could be a time crunch, and starting to authorize some of these standing officer directives, hearing officer directives, a little bit more. But that's something we can certainly look at.
Okay.
Okay. Any other thoughts or suggestions on this comment? Mr. Richardson.
Jason Richardson on behalf of Piedmont Natural Gas Company. Just wanted to offer support as well for the comments that were mentioned today, specifically by DEC and DEP and by other parties here today as well.
Thank you, Mr. Richardson. Ms. Boyd?
Yes, ma'am, Madam Chair. The next regulation is 103-848, exhibits.
Any concerns about that all exhibits need to be legible and readable? I think it would help all of us. Hearing no concerns on that edit.
Yes, ma'am. The next is 103-852, service of orders.
And this is where we're back to the circuit court and practice and federal court practice, is it not?
And if I'm
Mr. Torini and then Mr. Ellaby? Or either one?
What differentiates the commission from circuit court is we do, I think the rules are triggered differently. We have these, either rules or statutes in various places say within, the time runs within receipt of an order or something like that. That may or may not be a substantive distinction. I guess if you adopt this regulation, it no longer is. I don't object to confirm, I want to make clear, I don't object to confirming receipt of orders. I'm just trying to eliminate the rest of it.
I understand. And I actually think that that's from a case law that about the receipt of the, I think it's an old Carolina Power and Light
Yes, ma'am.
field case, I think. Mr. Ellaby.
Madam Chair, Frank Ellerby for Duke Companies. I just wanted to give a little bit of background on that I looked it up. It's Rule 5 of the Rules of Civil Procedure, which is the rule for service. And once the court has jurisdiction over a party, so the rule about service is different. If it's initial service where you have to get the summons and complaint served, then that's a different rule. But once the party's in the case, service is effective on mailing. And then the court, so that's Rule 5, Rule 5B says 5B1, the rule is effective on mailing. And then there's additional time for service by mailing, which may or may not apply. But there's also the court in May of 22, the South Carolina Supreme Court adopted Rule 613, allowing for service by electronic means in the trial court. And once any party is in the case, service of pleadings and orders and anything else ought to be by electronic. If you've agreed to electronic service, then service is effective upon that being sent to your email address, just like service of mail is affected by sending it to your address. And it's the responsibility of the lawyer to make sure that the inbox is covered and that other people are monitoring it, which is the way it works in federal court. You can sign up any number of people to also be
And I think most attorneys do that they have an assistant or a paralegal or somebody else to receive to kind of help them keep track of these
That's right.
things.
The state court system works in the same way. You get the service of a whole number of people. And I'm sure solo practitioners would have some way of addressing that. Isn't that right, Mr. Torini? There you go. Anyway, I hope that a party in a case shouldn't be able to avoid having to comply with an order by refusing to acknowledge the service.
I don't know that's going on. It just seems to be the same.
Right. It's very
over
rare,
and over and over.
But it is problematic for those of us who are trying to follow the rules when somebody does do that.
Okay. Thank you for that information. Rule 613 and Rule 5.
Madam Chair, if I may just add one other thing. So related to Mr. Terani's issue of e-service of documents from the commission other than orders, that regulation, I guess if the commission decides to amend 103.817.1 to basically state when documents are because 103.817.1 relates to e-service and e-filing. So that's if an attorney electronically files through the docket management system. And it also includes notices of electronic filing. There are certain circumstances where staff activates an e-service, meaning maybe they received a hard copy of a document from someone who doesn't have email and we electronically serve the parties in the docket. I'm just trying to think of the circumstances Mr. Terani is talking about now. But if you decide to make any changes regarding, once staff emails you, you don't need to confirm receipt, this could be the time to do that under e-filing, e-service, which is 817.1. Now, there's another regulation that relates to the commission electronically serving its notices and pre-file letters and transmittal documents. Can you give me a second? I think that's under 817. I think that's a different discussion because we at times will have to have proof that someone received notice of hearing. And those could be additional documents that Mr. Terani is referencing. You do need proof that someone actually, received notice of a hearing if you want to hold them in default or whatever. Yes, that's under 817. Madam Chair, would you through you, could you ask Mr. Rainey, that's the type documents he's talking about, notices
Mr. Terrain, are
generated
you
by the
following what Ms. Boyd is saying, and can you respond to that? And do you want to see the reg?
No, I
Okay.
don't really need to see the rag. What I probably ought to do is go through my inbox at some point. Ms. Boyd, Ms. Boyd's educating me that what they're doing has changed. The methods have changed, and so it could be that I'm remembering having to accept service on things that I'm no longer having to accept service on. But I think obviously a hard document that might make sense. I think email exchanges perhaps now between, say, the hearing officer and parties are being served. That may be an instance. Again, I would need to look, and I can stand corrected on it. Perhaps just it may be as simple as changing the subject matter or the sender or something like that, so that an order stands out in the inbox and is clearly differentiated from other service.
Well, I think that when you reference the emails, I think emails between anyone at the commission and the parties has to be posted to avoid.
I'm not disputing they have to be posted. It's whether they have to be
But
served.
once it's posted, I think there's an electronic filing notice that goes, is it not?
Okay, so
that was filed in the docket. I think anytime, and correct me if I'm wrong, Ms. Boyd, but anytime something is posted in the docket, the parties to that docket receive some sort of notification that a matter was posted, was it not?
That is if it is electronically filed. So once
Okay.
it's electronically filed, let's say Mr. Terraini files an application today. As soon as he uploads that document to our e-file docket management system, all the parties in the case receive an immediate notification that he's just e-filed the document. Then our clerk's office employees review the document. If they find that the service should be accepted, the filing should be accepted for processing, then Mr. Terraini will receive he'll receive a notice of electronic filing. That's what he should receive. And that's a document that says, basically it says at the top, notice of electronic filing. This is the document. Here are the persons who've been served and they represent these people. And then there's a link to the document at the bottom.
That they can click on and access the link.
That's correct.
The document.
They can access the document. Now, Madam Chair, there's so many different scenarios. I would need Mr. Terraini to let me know what irks him the most. Because I mean, we're fortunate in the clerk's office. We see all kinds of filings. It's not just one type. One that I think staff would that we're going to have to serve anyone would be, as I said, our notices. We have to keep a record that people have been properly served about, proceedings or they've been, a hearing. We're going to have to e-serve you that. But there could be other instances that he mentions that really bother him, and I understand that maybe we can work with.
Mr. Terraini, I can guarantee you she's not going to give me the opportunity to tell her what irks me, but so
I will get with Ms. Boyd. I think I'm taking enough of a beating today.
Oh, I'm not picking at you. I just appreciate your comments. I really do. And I think the commission does. Okay. Anything further on that? All right.
Moving on, Madam Chair. 103-853, finality of decision.
Any comments on the edits that is adding electronic service to one and just doing a parenthetical around a subpart in another? Any comments? Hearing none?
All right. And then 103-855, presiding officer's proposed report.
Any comments on deleting that? That's in keeping with the other change regarding the report. Okay. Shall we go back?
Yes, ma'am. Let's go back if that's your preference at this time to 103-823. And I think the changes begin under A3, content of applications.
Does anybody need a break? We've been going not quite an hour and a half. Does anybody, our court reporter, can we take a 10-minute break, ladies and gentlemen, and that'll allow everybody to get their thoughts together as we delve into the meat of this one, and we'll be back at 10:30, please. I'm sorry. Good morning and welcome back to the Public Service Commission in this proceeding in docket number 2022-300A, the review of Chapter 1, Article 8, Practice and Procedures of the South Carolina Code of Regulations. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin and Commissioner Justin Williams. Appearing in the hearing room, we are present in the hearing room. We have Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. We took a break there for a few minutes, and before we delve into the amendment or the proposed changes to Regulation 103-823, I want to ask the parties present. I believe that the Administrative Procedures Act allows us to consider both written and oral communications. We have written communications that a number of the parties have filed in this docket, and I think we've had a motion from at least one party, maybe two, that comments that they had made at the stakeholders proceeding also be moved in, and I think the commission had accepted that. Does anybody feel the need that they need to move their written comments into the record here? I think that they are there for our consideration as well. Just want to make sure that nobody feels like their written comments are not being considered, because they will be. We okay on that? Okay, thank you. Ms. Boyd?
Okay, Madam Chair, so we will return now to Regulation 103-823, and in particular, Section A3, and that regulation relates to applications.
Okay. I know there are going to be some comments. Do y'all, I have an appearance list that I can just go down and recognize parties if that's okay with everyone. And the first one on mine is South Carolina Telephone Coalition. Is there any comments on Regulation 823?
No, Madam Chair.
Okay, thank you. And Lockhart Power, Mr. Green?
Thank you, Madam Chair. No, we had just submitted comments. We appreciate the differences between small and large electric utilities. We just asked for input on the nature of the required filings, the forms as they would be finally approved.
Input, and I think is it clear that the commission would consider the forms and either approve or disapprove or edit or modify by commission order, not as part of the regulation?
Yes, that's correct.
Okay.
We just asked for input on that at that.
Oh, okay.
time.
At
Yes.
that point, I understand. Thank you, Ms.
Thank you, Chair.
Thank you, Mr. Green. Piedmont Natural Gas.
Yes, Madam Chair. Thank you again. We just support DEC and DEP's comments, and we agree with their positions offered. We just echo those comments again and from our January 6th written comments. Thank you.
Thank you, Mr. Richardson. Blue Granite.
Thank you, Madam Chair. Largely, we'll rest on our written comments, but do want to introduce Zach Payne to give a few additional comments on Regulation 103-823.
Mr. Payne.
Thank you.
It's nice to see you again.
Nice to see you. We do appreciate the efforts on a 9.5 to change the cost of service study requirement from 3 years to 5 years. Based on what was said this morning, we do still have a little hesitancy of making that any kind of periodic requirement, considering most of the water and sewer companies haven't really filed cost of service studies. I think it would be helpful if everybody does have them, we get to see what we're able to, what benefit comes out of it before we make it a requirement to do it for every 3-5 years, just a consideration maybe on that. And then also still with the performance metrics, section A17, again, our comments address this, the ones filed on January 6th, but it's still very vague of the performance metrics. There's nothing listed, much less what process would be established to generate performance metrics or what they would be used for. Still gives us some concern on that point.
Okay. Thank you, Mr. Payne. Southwest Water Company.
Thank you, Madam Chairman, or Madam Chair. We've submitted written comments, and I'd just like to elaborate on them a little bit more. We do appreciate the extension of time for the time period for filing cost of service studies. But we would reiterate that perhaps that would be better done on an as-needed basis, or that determination of a need for a cost of service study should be made on a per-case basis. These studies are really expensive, and if we're talking about a utility with, say, 1,000 people, and the cost of service study is going to cost the same for a utility with 1,000 as it is for one with 3,000, pretty much. And that, I think we gave an example of $56,000 in the Kiowa Island case, and that I don't believe included the expense of ORS's cost of study, because we actually had two costs of service studies in that case. So we're not opposed to the idea that a cost of service study could be required, but we think this could be really imposing an unnecessary cost on customers in some cases. These utilities are unique. Sometimes they're not appreciable differences between customer classes and so forth. So we'd reiterate those comments. I know I'm swimming against the tide here, but we would also suggest that direct testimony not be filed with applications, but perhaps be handled in the same manner as was just mentioned, and it could be filed within 4 weeks of the application. If applying that rule to rate cases might be appropriate as well. Thirdly, as to performance indicators, I'm reminded of a time, it was probably 10 or 15 years ago, where the commission undertook explored the issue of performance indicators for water and wastewater utilities. And we held a forum on it. We got input from various parties and discovered that it was a really thorny issue. And ultimately, the commission at that time decided not to move forward with this. We're not necessarily opposed to performance indicators, but we do think that rather than having them established as filing forms, so to speak, there probably needs to be a regulatory or a regulation promulgated establishing what they are and how they will be used, and that really would probably benefit everybody involved if those criteria were articulated with input from various stakeholders and had the force of regulation rather than were appended to applications.
Madam Chair.
Commissioner Caston?
You mentioned previously, when I guess this was mentioned or discussed, a thorny issue. What was the thorny issue?
Well, what was thorny about it, Commissioner Caston, is there was no consensus on what the appropriate indicators were. There were suggestions about secondary water quality standards. There were suggestions about customer service standards. Ultimately, it just became the commission at the time and staff at the time saw that it was the existing method of the commission taking evidence, weighing evidence from the parties, having the input of night hearings and public hearings, which at that time became testimony, they hadn't been previously, was sufficient. And that perhaps we're opening a Pandora's box by trying to establish these set performance indicators. So, you know, if the commission said this is a performance indicator but didn't say why X was a performance indicator but didn't say Y was a performance indicator, could the commission then consider Y, you know, for instance? Those were the issues. And again, I'm not saying it's a bad idea for this commission to have performance indicators, but I think they need to be established through some sort of iterative undertaking in which you hear from various parties and deliberate on what they ought to be and how they ought to be arrived at.
Well, I was thinking I saw, excuse me, either in comments, I honestly don't recall, but a suggestion that there be workshops or something with all the utilities, and you mentioned water, someone mentioned water, wastewater, but, you know, I imagine electric utilities, you know, a utility is a utility. Uh, would, would some process like that make sense?
Well, yes, workshops, just like you arrived at these regulations through a series of workshops in which your staff solicited input from the parties and arrived at a proposal for you in which it considered and accepted some suggestions and rejected others, you know, but we had a process that got us to this point. And now in the rulemaking process, you have a much more finished product to work with. This would be a much longer proceeding if staff had just thrown these regulations out and then we all had come in. You know, there's a year worth of work that's gone into this, and I think it's commendable for the commission and the staff to have undertaken that work. And I guess I'm suggesting if you're going to have performance indicators for utilities, a similar undertaking is necessary. And with all due respect, I don't think performance indicators for electric utilities are going to be the same as they are for water and sewer or telephone or what have you. I mean, we have different. I mean, you might be dealing with service interruptions. A service interruption for an electric utility is different than it is for a water and sewer utility. SSOs are a peculiar problem for sewer utilities. They're not applicable to other utilities. So I think there are a number of things. It may be a very worthwhile proceeding, but it's going to be a complicated proceeding and one that requires a separate undertaking.
Well, I guess just for my edification, I'm not speaking for anyone here relative to that.
Yes, sir.
Which I agree with you. I mean, there's no one size that fits all.
Sure.
And perhaps, at least what I'm hearing from you is maybe there's a thought that the commission is expected to develop some metric or metrics for utilities. Again, I can only speak for me, but I tend to think in terms of, you know, everybody, every system. You know, I was always taught you manage what you measure.
Mm-hmm.
If you don't measure it, you're really not managing it. So I'm assuming every system, whether it be water, wastewater, electric, or whatever, I assume measures something,
yes,
or manages something that is important to them.
Yes, sir.
So perhaps the suggestion to, and it may be different, you're saying, you know, electrical companies in this group or water, wastewater companies in that group. Is that what I'm hearing? Or?
Well, I guess what I'm trying to say is if we start with the status quo, I think just about any water utility comes to you in an application and tries to establish that it provides good customer service. And each one of us takes a different approach to it. We may have some common things, points of reference, but for instance, going back to Kiowa in its last case, the ORS concluded and the commission agreed that Kiowa provided excellent service. That was done based on a record presented to you by Kiowa. DeFusky may come in and present you different indicia of what they consider to be good service, partly because maybe they have different conditions. They have a an infiltration problem with water, and so their indicia may be how they address that. All I'm saying is that if we're going to have performance indicators, that seems to imply that there's going to be some common denominator. And if that common denominator is going to be arrived at as part of the filing requirements, then it necessarily is going to be a product of the commission. And seems to me logical that it would be handled through regulation, because first of all, you have to decide what these common denominators are going to be. And secondly, you have to, respectfully, I think you're going to have to decide what their impact is going to be on a rate case. Is that going to be something that is standardized? Is there going to be a certain demerit for failing to meet these performance standards, or is that something that's going to be considered on an ad hoc basis? I don't know the answer to all these questions, but I don't think. But I submit a process similar to what you've gone through with these regulations and others is got to be what determines.
Makes sense. And relative to like cost of service studies, whether it be a set thing, a set time, I think reading some of the I guess information we received, there was some concern about that. And I think you did, or someone just expressed that.
I did.
Should it be, and this is a rhetorical question, I'm not asking definitively, but should it be based on a time frame? Should it be based on if there's been a certain percentage of growth or demand? Should it be maybe based on a combination of those things, and just to check for allocation of services, is it correct allocation of services if there's been growth demand? What are your thoughts on that?
Well, my thoughts begin with the premise that the threshold for becoming a Class A utility is pretty low. You have 1,000 customers. That's not a big utility these days. It may have been when these classifications were originally arrived at. So the cost sharing that is going to have to take place between the customers for these cost of service, for the price, so I don't have to use cost again, of these cost of service studies could be significant. And rather than putting an automatic requirement in, I certainly welcome lengthening that time period. I mean, 5 years better than 3. But my point would be, let the company file the application. If ORS feels a cost of service study, a new cost of service study is necessary, either the company and the commission and the ORS can agree on that, as Kiowa did in the last case, or if there's disagreement on that, we can come to the commission and say, ORS wants us to perform a cost of service study. Respectfully, we don't think it's cost efficient, and you make that call. I just don't think it needs to be an automatic item in each case.
I was directing the questions his way, but I know others had thoughts or comments. If you,
I think we're pretty well covered. Tarini's said what we.
Mr. Payne, you need to speak up.
Thank you very much, Mr. Torini. I'm sorry all that got dumped on you, but I appreciate the input.
Thank you.
Thank you.
Mr. Torini, anything further? Well, looking at your written comments, I think you've covered. I just want to make sure. Okay.
Chair Belser.
Commissioner Carolee Williams.
Thank you. Mr. Torini and others, I noticed particularly in Mr. Torini's submittal that the reference to A95 and the cost of service study and the revenue of $1 million. And I guess my question is to Mr. Torini, but it's also to Director Boyd, how was that determined? Is a million, I mean, we're kind of back to that same question of Class A and 1,000 customers, but how was $1 million determined to be the threshold for the cost of service study? Is that an industry standard that I just don't know about yet?
Hold on. Commissioner, yes, ma'am. I see it under 9.5. I think we used NARUC NARUC Class A, B, C, and revenue.
Yeah, aren't the
for those
NARUC
two-
classifications based on revenues and
I
not
think-
customers? Is that correct? Does anybody?
I think our accountants are saying yes, Madam Chair. I think that's what
right.
staff use. Mm-hmm.
But $1 million.
I wonder when they were established. You know,
Yeah.
$1 million 10 years ago
Right.
is very different than $1 million today.
That's true.
So I'm just clearly thinking about it from an impact perspective. And
Yes, ma'am.
Yes, ma'am.
anybody know when those were established?
My guess is it would have been longer than 10 years ago.
I believe 98, sometime in the 90s.
Wow.
I found one state that had a threshold higher for Class A, but the NARUC standard is what we set.
Thank you. No further questions.
Commissioner Thomas?
Thank you. And again, to the issue of the cost of service study every 5 years, I thought that Mr. Torini, your suggestion of there being flexibility is reasonable, and I don't know how that gets written into the regulations, but I think that flexibility is the key. It's just too much potential for that to be too much money spread between too few customers. And I think we should think about how flexibility can be added to that regulation. That's all.
Do you have a question for me, Madam Chair?
No, I was trying to figure out what whose phone was buzzing. Thank you, Commissioner Thomas. Nobody else heard that?
Madam Chair.
Commissioner Urban.
Thank you. Just to follow up on the point that was made by Commissioner Thomas, we could put in the regulation that for Class A water utility, that kind of a burden shifting provision that says that a cost study may be requested by ORS between 5 to 7 years unless the utility can show by the greater weight of the evidence that it would be cost prohibitive and have to be passed on to the ratepayers. And then we could have a discussion about it. Kind of a short and evidentiary discussion, and then the hearing officer or commission itself could make that call, depending on the facts. Mr. Torini, what do you think about that?
I think that could be a very good way of addressing it, Commissioner. I would suggest the standard not be cost prohibitive, but cost efficient. But
right.
But yeah, I think that's a good way. And you know, candidly, ORS recently has been requesting cost of service studies fairly consistently, but that's also because utilities had not been doing them beforehand. So it could be that we're going to have a baseline pretty soon, and we can figure out where we want to go. But I like that proposal of Commissioner Urban's.
Because not every case is really the same. You've got different facts for different cases, and if there's some compelling reason why ORS thinks it is needed, then they would have the burden of coming in and making a showing by the greater weight of the evidence that they, why they claim they need it. And then the burden shifts to the utility to show that it's a cost-effective or cost-prohibitive decision to go forward based on facts on the ground and the experience of the utility and condition of their system and so on and so forth. Doesn't that seem fair?
I think your proposal makes sense, Commissioner Irvin.
Any other parties want to comment?
Mr. Payne for Blue Granite.
Yes, I'd like to add something from what Commissioner Caston had said, or had mentioned something about if you have like a change in the size of your system. There's something, with a cost of service study, unless you have some kind of change in your customer makeup or, to the assets in your system, you're not going to have much of a different cost of service study. So maybe building in some kind of conditional aspect that, if there's a change and we expect maybe a cost of service study would give you a different result for whatever, with a set of reasons, something like that rather than just making it because we need to. So as far as anything that could kind of maybe give ORS a reason to request or something to that extent, maybe just work something in there of, whether it's a change in the size of your plant, changing your customer makeup, something along those lines that there's reason to believe a cost of service study done now will be different than what it was before. Otherwise, it's hard to justify the cost, I think.
Well, that's a great idea. And so it would kind of be a show cause hearing, like a threshold hearing to decide, has a good cause been shown for a need to go to this expense, given the individual facts in the case. And ORS would have to carry that burden initially. If they don't, it's over. You'll wait another 5 years.
Madam Chair.
If they
I'm
carry
sorry.
it, and you get to respond. Excuse me.
No, Commissioner Irvin, I'm sorry. I didn't mean to cut you off.
That's all right.
Commissioner, are you through?
Yes.
Ms. Given.
Thank you, Madam Chair. I think the only thing I'll note from ORS's perspective is that I'll need to confirm with my client to determine our position on Commissioner Irvin's proposal and address that, whether it's through follow-up comments or an email on the docket.
Okay. Thank you, Ms. Given.
Madam Chair. Oh, I'm sorry.
Commissioner Carolee Williams.
Thank you. Ms. Given, would you also look into the dollar amount? And I guess I'm questioning the utility companies as well, whether that threshold is the appropriate threshold.
You're talking about the revenue amount?
Right.
For companies over with $1 million or
Right.
more, the Class A, Class B, or whatever. Does that clarify, Ms. Given?
It does. Thank you.
And I guess I'll ask the companies if they feel like that number is the appropriate threshold. That's what I was trying to ask earlier.
Commissioner Williams, I believe we would support updating the classification standards across the board. I mean, the difference between say a PWR, Palmetto Wastewater, and a Palmetto Utilities, they're both Class A's now, and the difference is immense. So I think that's part of the minimum filing requirements issue too. Yeah, we'll comment on that.
Okay. Commissioner. Oh, excuse me, Mr. Payne.
I don't know that dollar threshold's going to make as much difference for Blue Granite. Just if it applies to anybody based on dollar threshold, it'll probably apply to us. So.
Okay. Thank you.
Commissioner Caston.
Thank you, Madam Chair. And Ms. Givens, I don't know the right way to do this. Is a suggestion, or at least what I'm hearing relative to, say, cost of service studies and such. This process, and I guess folks asking questions after this process, would probably be a good thing. For example, I was thinking about the cost of services study too, and primarily thinking about, okay, were allocations changed and why? Similar to the performance measures, at least in my view, there is no one size that fits all. There are some things that I think could and should be uniform. For example, something that came to mind, Mr. Torini, say from a water utilities perspective, say, well, we called it unbilled water. I think AWWA calls it unaccounted for water. Things such as that. Some things like that may be more universal in the sense that you know, do you have 50% unaccounted for water or 10% unaccounted for water? But my point being, relative to even the cost of service study, it is something that I think worth deliberating, talking amongst parties and ORS, and to do what we need to do when we need to do it, but perhaps not just do it as a matter of course. And I think that's what I'm hearing. Is that correct?
That's, Commissioner Irvin came up with a way that would allow you to consider it, but not necessarily order it on a periodic basis. That seems reasonable. Or if you just want to consider it on, I mean, the way you are now, the way you're set up now, there's nothing to stop ORS from saying, we think this company needs to give you a cost of service study. For that matter, there's nothing to stop ORS from hiring an expert and conducting a cost of service study. So you're kind of in a position now where if somebody feels a cost of service study is warranted, they can come to the commission and say, we think the utility needs to provide you one. But if you want to put that in regs, I don't see any harm in that. We just, like you said, the automatic requirement doesn't seem to make a lot of sense.
Well, I don't know that I necessarily said that, but I'm not saying I'm an advocate of that.
It's worth a shot.
And Ms. Gibbons, I don't think I said we need to tell ORS stop anything, but I do think this is good conversation, good thought process, and it's worth pursuing further. Thank you very much.
Mr. Torini, how long does it take for a water utility or water and sewer utility to conduct a cost of service study?
I would need to follow up on that, perhaps.
Well, I think
I know we did one within the confines of a rate case last time, so it's not an issue of time; it's an issue of expense.
Well, probably both.
Well,
but
yeah.
Well, and where I was coming from is since we're talking about minimum filing requirements with the application,
yeah.
that I mean, I was trying to look at it from that standpoint. That once a notice of filing is done, it's kind of difficult at that point to say, wait a minute, before they can file, they need a cost. So I'm just trying to think of it in the parameters of how our cases progress. Is where I was trying to come from.
That's right, Chair Belser. It would have if you had this situation where after filing somebody said we need a cost of service study, it would have to be presented during the course
of the hearing,
the rate case.
Yeah. Okay.
Which, is doable.
Thank you. Appreciate that. Mr. Payne, do you have any comment on that? Just don't want to leave you out.
Yeah, I don't have anything to add on that point.
Okay, thank you. Any further comments on that? Let me get back to my list. What did I do with my list? Give me your list. Thank you, Mr. Torini. Duke Energy, both companies, DEC and DEP. Oh, there I am.
Thank you, Chair Belzer. Katie Brown for DEC and DEP. Just a few brief comments on 103-823. As the companies have expressed in prior workshops with commission staff, we're generally supportive of the concept of minimum filing requirements, but we've noted that each utility has a different method of maintaining its books and records and related schedules that support rate case applications. The companies appreciate the Commission's interest in receiving additional information related to rate case filings and are amenable to providing the data set forth in the proposed regulation, as long as it's in a manner that aligns with the way the companies currently maintain their business records. Because the burden is on the utility to establish its case, the utility should be permitted to file their applications in such a way that makes sense for the utility. As outlined in our previous iterations of comments filed, I believe in 2020-247A, as well as this current docket, the companies had some concerns about the language included in some of the schedule templates themselves. And as we discussed earlier, schedule templates were not included with the proposed regulation. That being said, based on the information presented today in commission staff's PowerPoint, it sounds like the process envisioned is one where the utilities would file schedules for commission approval. And we support that approach and believe it would allow for the companies to submit this information that the commission is requesting in such a way that aligns with how the companies maintain their books and records. I'm happy to answer questions, but I'm going to turn it over to Ms. Elliott here to provide some commentary on the specific MFRs. She's the expert there, but I'm also happy to answer questions.
Thank you, Ms. Brown. Ms. Elliott?
Well, good afternoon. Can y'all hear me?
You kind of have to get close to that microphone so everybody can hear you. Thank you.
Okay. Good afternoon, Chair Belzer and Vice Chair Powers and the other members of the commission. Thank you for the opportunity to come before you today to speak on behalf of DEP and DEC. I'd also like to thank the commission staff for conducting the 2 previous workshops back in June of August of last year. It's been a very collaborative process, and they had given us the opportunity to provide some oral comments in addition to our written comments on the proposed minimum filing requirements. And we do appreciate that some of the originally proposed minimum filing requirements were reconsidered, and others were revised to make them more in line with our regulatory framework here in South Carolina. I think it's important to note that the current proposed minimum filing requirements have been largely adopted from Florida. And Florida operates in a little bit different regulatory construct than we do here in South Carolina. They use forward-looking test year models and multi-year rate plans to set their rates, where here in South Carolina, we use historical test periods. So to echo what Ms. Brown said, the DEP and DEC are generally supportive of the concept of minimum filing requirements. We just want to make sure they're the right ones for South Carolina. And so where some of our concerns lie are with the schedules, which we've talked a lot about that. But one of the things to note with the schedules is that they weren't part of the proposed regulation, but they included an explanation that provided a little bit more context around what was specifically being required. Because right now, absent the schedules, based on just the title that's in Regulation 8, it's not necessarily clear as to what the expectations will be as to what we are to provide to the commission in our application. And so we do like the idea of being able to craft the schedules to fit how our accounting system works, but we also want to make sure we're meeting the intent of the regulation. And so right now, some of them are, pretty self-explanatory, but others could be left up to speculation as to what is being required. And I can give you a couple examples. So and just using as an example, so if you look at, MFR B-11, miscellaneous deferred debits, and B-12, other deferred credits, probably from DEP and DEC's perspective, we would interpret that to mean any deferred debits and credits that have been included in the calculation of our revenue requirement. But that may not be the intent of the regulation. That may be, give me all your deferred debits and credits, because not every deferred debit and credit that sits on our balance sheet becomes a component of our rate application included in the calculation of our revenue requirement. So that's just an example of what we mean when we say it's not necessarily clear just looking at the description that's in the regulation as to what the expectation would be. I want to make sure. And one of our other concerns lie with some of the requirements that are requiring information for multiple years. And so again, these are largely adopted from Florida, and they do use a forward-looking, forecasted test period. And so where you may need, multiple years of history in a jurisdiction where you are setting rates on a forecasted period, because you may be trying to, analyze trends or, make a determination as to whether the forecast is reasonable. Here in South Carolina, we are required to use a historical test period. And so we're not sure if that would be value added information to provide multiple years, for example, of, cost data. If we are required to use, we're looking back at what has happened, and that's what we're setting our rates on. We are allowed to make adjustments for known and measurable changes, but we just kind of are concerned about, maybe the additional work that would be required and the additional cost to customers of providing additional information that may not be relevant or useful in the purpose or in the context of the rate application that's before the commission.
Okay, Madam Chair.
Are you okay to take questions?
Yes.
Or do you
No,
want
yeah.
Commissioner Castro?
Yeah.
I'm sorry if I'm interrupting your train
Oh,
of
no,
thought,
you go right ahead.
but I know it'll interrupt mine. I wanted to make sure I understood that last part as far as, well, one, my first thought was, if you can answer this, or feel comfortable answering this, which do you like better, Florida's way or our way?
Well, again,
South Carolina's
we're
way?
not opposed to minimum filing requirements. Our goal is just to make sure there are requirements that fit the regulatory framework that we operate in here in South Carolina.
I see why you have your position. Relative to the, I guess, additional information, looking at multiple years, we, have a historical test year, and you had mentioned you're not sure what the relevance would be, and it could be additional cost to the customer. And I don't know how you do your stuff. To me, it just seems like pushing a button and spitting it out, and I'm sure it's not that simple. But could you elaborate on that just a little bit? Because and I'm not saying that it's right or wrong. I'm just one of those guys that likes to see data, trends and that kind of stuff. But I want to understand what you're saying, why, if you can, a little deeper.
Okay. And I will use MFR C-3 as an example. So that requirement requires 5 years of a 5-year analysis of changing cost. And so one thing that's not clear is when we say changing costs, what costs are we referring to? Are we talking about operations and maintenance costs? Are we talking about all costs that would include, income taxes, property taxes, depreciation? Like, what do we mean in the regulation when we say changing costs? And, from a South Carolina perspective, those costs will be based in a rate application would be based on whatever historical test period is used in that particular case. And so, while we could provide 5 years of historical data, at the end of the day, the rates would be set on that test period historical cost amount.
Understand.
May I ask a question?
Yes, please.
Is not looking at changes in cost over a certain period, whether it be 3 or 5 years, is that not important or needed to try to normalize the test year? I understand that you've mentioned about pro forma adjustments, but what about normalization?
Well, and even with normalizations, we're using an actual result and we're normalizing to that. So for example, in our most recent, South Carolina rate case, one of the things that we normalize for is labor. And so what we're trying to do in the normalization circumstances, we're trying to normalize costs so that they're representative of what they would be at the point in time that rates go into effect. So if you use, for example, labor, that's one of the things that we typically normalize in a rate case, but we're using actual labor cost at a point in time and not necessarily historical labor cost.
Doesn't or used to, I don't know if they still do, but doesn't ORS ask for like 3 or 5 years of trial balances to reflect
I
have
don't. We
the,
get a lot of
maybe a
discovery, and
trend of?
I know sometimes they do ask for historical information. I can't speak to any specific examples at this point, but we do get a lot of discovery, and sometimes it does request historical information.
Okay, thank you.
When, if I may continue, and then I'll wrap this up, I promise you. Thinking not only in terms of what Chair Belzer said, but acknowledging that it is a test year, it is a point in time. Or is Duke saying that it's not, that you don't understand or see why it may be of value to, say, the commission to perhaps look at what things have been, even historically, from a trend point of view, and that is this an anomaly, or is this a trend? Is it just an outlier? Does that make sense?
Yeah, and I guess if the commission maybe wants to make a determination and deviate from, the historical test period in their ruling, but typically ORS typically makes sure that, what we're putting forth on a historical basis and any pro forma adjustments. And I mean, they do a thorough audit of all our pro forma adjustments to make sure that when we are normalizing costs, that it truly is a representation of what our costs will be going forward. So I'm not here to suggest that there's no value. I'm just simply saying that we do operate in a different regulatory framework than Florida. And so this requirement is specifically lifted from Florida's minimum filing requirements. And I'm just saying that I could see how that could be the case in Florida because they are setting their rates on a cost basis that's based on forecasted data.
I must be honest, I don't know if it was lifted from Florida or not, but I tend to think those ways, and I didn't know Florida had stolen that from me, but that's okay. And I know I'm just speaking to you, but I guess everyone in the room, would apply relative to, you've talked about forward-looking and multi-year rate plans. What does the company have an opinion, a view of that, a preference one way or the other?
I mean, I will say currently we do have jurisdictions that operate very similar to Florida. I mean, we do have a sister company in Florida, so they do operate in that framework. It's just here in South Carolina, we do use that historical test period, but there are other Duke jurisdictions that also use forecasted and multi-year rate plans to set their rates.
Does Duke, South Carolina, have an opinion on that or a preference one way or the other?
I'm probably not the person to answer that.
Okay, I'm sorry. I'm just
as we sit here today.
And it not necessarily Duke. It could be Dominion. It could be
Commissioner?
Yes, ma'am. Yes, sir. I'm sorry, Mr. Treen.
I'll go out on a limb and say that Southwest Water would favor forward-looking test years and multi-year rate plans. I'm pretty sure of that.
Commissioner Caston, on behalf of Dominion, I don't think the company has a position per se, but I can explain the differences in a way that may help. And this used to be the practice at FERC when they did a lot of cost of service regulation. Rather than saying this was the test period and these were our costs during the test period, and then you'd go through the process and probably something like a year later you would get new rates, but the rates would be based on a test period that was already a year old, more or less. And you'd also have various adjustments that would even bring you back to the midpoint of the test period so that you were more than 12 months stale with the rates that you were imposing. At FERC and in the other jurisdictions, the company says, we think these rates are going to go into effect on this date in the future, and we're going to give you a projection of what a year of costs and revenues are going to be beginning at that future date. So you don't have what's called regulatory lag. You don't have that gap in inflation and growth and costs between the end of the test period and when the rates go into effect. The rates are based on a forecast. Now, if you're doing a forecast, you have to be very careful to be sure that your forecast is reasonable. And that's why you have so much detail in the filing requirements for forecasted test periods. because you're not dealing with hard facts. You're not dealing with actual accounting. You're dealing with what the company thinks is going to be the case a year from now. And you've got to be very careful to be sure that the company isn't biasing that in an unfair way. And that's why you have the level of detail you have in Florida and looking at, all right, we want 5 years of data, so you're not just cherry picking something that's going to give you a result you want. There's no cherry picking in a historic test year. It is the actual expenses, the actual revenues for that year that are changed through pro forma adjustments to take out known and measurable changes, like the loss of a major customer that you know is closing, or some cost that's going away because it's fully amortized. It's very discrete on a factual basis, so it's a much different analysis that you have.
Well, Ms. Heritage, I hadn't forgotten you, but before I leave, my final thought, and if it's okay, Mr. Ziegler, as I think about what you just said, if somewhere down the road that were to occur some way or somehow, other than these statutory required adjustments, then I guess perhaps other adjustments would more or less be incorporated into forward-looking projections. Is that a fair assessment?
The utility filing that forward projection can make any projection it thinks it can support. So there's no, obviously they need to support it to say, okay, our wages and benefits have been rising by X%, but inflation is now X plus 2%, therefore we're putting X plus 2% in our numbers. So that the utility has control over what it puts in its forecast, but it's got to stand the test of is it reasonable, and is that something the commission will accept?
Thank you. And Ms. Elliott, I apologize, I have no more questions. No, this has been very informative and enjoyable almost. We should do this more often. Thank you.
And the only other comment I was going to make, and I appreciate that we appreciate that this has been added. So in Part A, Section 3, this is where it talks about the schedules. And so it says all schedules must be filed at the South Carolina jurisdictional level, if applicable or available. And all schedules essentially must be approved by the commission. And so I bring up the South Carolina jurisdictional piece just because both DEP and DEC, as you know, are dual state systems. And so a lot of the requirements aren't necessarily readily available on a South Carolina jurisdictional basis. And there's been a lot of discussion here today about the cost of service study. But that's essentially the mechanism that DEP and DEC uses to get these system costs that are sitting on our accounting system down to the jurisdictional level. And so it was really important for us to get that included because not all of this information we can just push a button and it's available on the South Carolina retail basis, nor is all the information going to be relevant for a rate case filing. So for example, our balance sheet, every single account that's on the balance sheet isn't going to be part of a rate case application. And so we just wanted to make sure that the accounts that were going to be part of the rate application are the ones that would be available on a South Carolina jurisdictional basis, and that's done through our cost of service study.
Ms. Elliott, and I appreciate the comment that Duke is not opposed to minimum filing requirements. They just want to make sure that they're applicable to Duke's business, and I think other utilities may have the same feeling. One thing that strikes me about minimum filing requirements is I'm hopeful that having greater detail in the minimum filing requirements may obviate some of the discovery that comes from the various parties if there's more information included with the application.
Well, and some of the information that's in the minimum filing requirements is information that's part of our application and testimony and exhibits anyway. And so we can appreciate, wanting maybe some uniformity around how that information is presented. And so we fully support, maybe presenting it in a uniform order, but having a little bit more flexibility in maybe how the information is presented so that we can produce the information in a way that aligns with how our books and records are maintained.
Okay. You've mentioned the Schedule C3 on the 5-year analysis change in cost. Are there other specific schedules that give you heartburn as far as because I think with the way I'm understanding this, rightly or wrongly, is if we at least have the structure of the minimum filing requirements, the actual templates, the actual schedules could be or looked at pursuant to a proceeding that would commission order would come out. Now with the electrical utilities, it's a little bit different because we really only have 4 operating in the state, so that's a more finite number. Water and sewer, it's a little bit different because we have so many and the sizes vary. So, but are there other schedules that just you don't feel are relevant to how Duke would present a rate case?
Probably another example I would use is B-3.
I'm sorry, did you say
B-3. Again, the 2-year balance sheet. The information could be provided, but again, the balances that we will put forth in a rate case are going to be based on the end of test year balances. And so you could, get that from maybe a 1-year balance sheet look. And a lot of our concerns previously wasn't necessarily with the requirements as they're outlined in the regulation. It was more with once we got to the schedules and we saw, because some of the schedules were pre-populated with fields. Other schedules were more free form, so you could kind of present the information the way you felt it was appropriate for your utility. So it wasn't necessarily, once we maybe reconsidered some of the original ones and got down to what has been presented today, a lot of our concerns lied with the actual schedules and what was being requested in the schedules. Because the schedules did include there was a schedule for each requirement, and it included an explanation at the top of the schedule so that you knew exactly what was being asked or requested. And then there were, in some instances, additional columns of things that needed to be produced. And some of that information isn't necessarily readily available, and so there would maybe need to be some manual intervention to produce that information. So I think that's where most of our concern lied. And so when we got here today and heard that maybe there's an option to propose schedules that we think may be appropriate to meet the requirement and have the commission approve those schedules, we would certainly be amenable to that approach.
Okay, thank you. Commissioners, anything further? Ms. Brown.
Chair Belzer, are there any, I just wanted to follow up on something about the proposed regulation. In 103-823 A3, it says all schedules must be filed at the South Carolina jurisdictional level if applicable or available. And then the next sentence says all filing schedules indicated below must be filed with the commission in the order as outlined and schedules approved by the commission. I understand from Ms. Boyd's presentation today that the intention is for utilities to submit these schedules for commission approval. I think there's still some ambiguity in the regulation there as to that point. And I think that was maybe a point of some confusion that we made in our earlier written comments, and I think that could probably be clarified. That what is intended is for the utilities to submit proposed schedules for commission approval.
Okay. Do you want, we do hold the record open for I think it's 5 days after the hearing for any additional comments that if anybody wants to file, do you want to make that clarification there, or is this sufficient for you?
I think that we could provide some proposed language in a filing subsequent to this.
Okay. Just everybody be aware. I'm sure y'all all are aware of that requirement that we have to hold the record open past this hearing to receive additional comment.
And Chair Belzer, I did want to point out one other thing that's specific to specific requirements. So Schedule C-14 and C-15A, the title indicates, for C-14, it indicates performance indices as ordered by the commission. And then C-15A says statistical information on internal operations as ordered by the commission. So again, right now, we're not clear as to what those indices or what statistical information the commission would be expecting there.
Okay. Thank you for pointing those out. Commissioners, any further questions of Ms. Elliott or Duke? Thank you, Ms. Brown and Ms. Elliott.
Thank you.
Dominion Energy.
Thank you, Madam Chair. Dominion Energy wants to begin by thanking the staff for their incredible diligence and care in moving forward with this proposal and for making a number of suggestions that are quite helpful to the process. But nonetheless, I have the rather unenviable task of saying that Dominion doesn't support the minimum filing requirements in the current format, and I'd like to explain why. Presently, well, let's back up and talk about what it's like to file a rate case. It's a very complex and time-consuming process to close a test period, finalize all the accounting data, review those final accounting numbers, take them and then put them through the process of determining what a revenue requirement is, allocating that revenue requirement through the cost of service data, which also has to be based on the test period. So that's coming in at the, as you begin that final process of preparing a rate case. Then once the revenue requirement is done, you've got to take that and put it through the rate making process and actually create individual rates and be sure they all work. Your accounting folks have to look at all of the deferred debits and other potential pro forma adjustments that need to be made in those accounting data to be sure that they're correct and supportable and appropriate. And it is quite a pressed situation because the people who are doing that work, I think you'll be happy to know, aren't just standing around waiting for a rate case to be filed every couple of years. They're working in other jobs very diligently, and this is something they have to do in addition to what they ordinarily do. And so the more you put into filing a rate case, the more it's going to cost the utility because they're going to have to start staffing up with more people. Now, what is happening today, which I think the Commission should be very happy to hear about, is there's an extraordinarily good relationship and a collaborative relationship that's taking place between at least the major electric and gas utilities and the Office of Regulatory Staff. As I pointed out in the comments that were filed in the prior workshop docket, before a rate case is filed, ORS and the utility sit down and talk about the data needs that are required to support that rate case. The overall outline of the rate case is discussed, and ORS begins filing discovery related to the rate case with the company before the case is filed to look at the data they think is going to be important for the ORS as the primary regulator on the ground to understand what's in those filings. And in fact, the initial discovery responses, which often are hundreds, if not thousands of pages of detailed data, are provided to ORS in some cases within a week or 10 days of the filing of the rate proceeding. And that's an ongoing process that I think bears a great deal of fruit. What that allows is for the data that is needed to assess a rate case to be tailored to the specific case. So you're not going through the one-size-fits-all model. Now, we did a little exercise to look at what it would take to meet the requirements of the Florida statute, of the Florida regulations. And the original regulations here on minimal filing requirements were taken pretty much verbatim from Florida. And in DESC's last electric rate case, it took approximately 5,700 hours of staff time to put the application together. And that's not counting closing the books and doing the other standard accounting things. And that was an application under the old regulation that was, it was 260 pages of data. So not a slim set of data at all. In Duke Energy's Florida rate case, it was closest to the date that we had the workshop. There may have been another one. I haven't gone back and rechecked. It took a filing of 3,012 pages of data to meet those minimum filing requirements. That's a huge amount of work. Rough estimate, 10 times what it takes today. Now, what's the value of the data that you're getting if you do that? How is that creating benefits to customers? Well, part of the problem with that data is it's going to be stale almost the minute it hits the filing, because ORS is going to be going back, as it should, and the other parties, and saying, we question this expense. We think you ought to tweak your cost of service analysis. We think these changes need to be made. So that data in the current structure, that process takes place while the case is being prepared and while the testimony is being prepared for filing. And so when you get to the hearing, you're dealing with a very different rate request typically than the one that was originally filed. So the data that you're causing the companies to spend a great deal of what ultimately is the ratepayers' money to put together is really not going to be much use to anybody by the time you get to the hearing, because all of that will have been changed with the necessary and important work of scrubbing that data through the regulatory process. And it's also the case that when these cases move forward, there are often settlement discussions that take place such that in the settlement itself, decisions are made as to how to adjust the data. And that's going to further make what's filed at the outset less and less valuable. So we question, the company questions the value of the data. We'd also point out that the collaborative process that's going on today with ORS is one that requires a great deal of time and effort. If you divert the people who are putting the application together from that process to put together several thousand pages of accounting data to file with you, that's going to impede the ability to do what we think is the most valuable and collaborative part of the process, which is what's working out with ORS. And by the way, it's not just ORS, because as soon as parties intervene, they get all the data that ORS has accumulated. And so everyone who is part of the case gets that data eventually. The company sees this as an admirable effort, but one that we don't think is going to bear fruit for the customers in a way that's going to support the cost and the effort involved. And that is the principal objection that we have. I think it makes great sense to say, let's do this on a tailored basis, but I worry that you will also now be having a proceeding to have a proceeding. You'll have to have a pre-rate case proceeding to see what the application is like before each rate case. That's going to be more burden on the commission, on the staff, on ORS, and everyone else. And that's going to have to be taken into account when you consider where this leads you. The final point I'd want to make is the last piece here, which is the requirement that the company file its direct testimony with the application. As we said in the other workshops, the company has no problem filing the direct testimony quickly after the application is filed. But there's really not going to be much use made of that testimony during a 2-week period between the filing of the application and its finalization. Often there are important changes that are being made, issues that are being surfaced and resolved as the case is going toward a final decision to file. It's much better to let the company witnesses have 2 weeks to finalize that testimony and not require them to be doing all the other work at the same time they're putting together testimony about, how to explain that. And so I think the 2-week standard that you have later in the regulations, and I don't have the number right in front of me, is the right. I guess it's 845C. That's would be very helpful in terms of the process of this. I hope you would recognize that utility companies, the ones that I've dealt with, the large ones, I'm sure the others are the same, but particularly the major companies have been bending over backwards to try to get the information out there as rapidly as they can with the staff they have, with the pressures they have to be efficient, so that these cases can be properly litigated before you. I see that collaborative process as the way to go forward in the future, and any sort of one-size-fits-all predetermined filing of multiple pages of data, which will be outdated almost as soon as it's filed, is not the appropriate way to go. Those are my comments, Mr. Chairman. Madam Chair.
Madam Chair.
Thank you, Mr. Ziegler. Commissioner Irvin?
Thank you. Very good points that you've brought up in your comments there. And it leads me to a couple of questions. One, would Dominion be willing to consider a provision, a regulation that would say that you're going to be limited to a rate increase every 2 years, no sooner than 2 years from filing to filing, and that way you're pulling this information together only every other year, so to speak. Does that make sense? It would cut the cost in half. It would free up a lot of time for your employees and staff. It would also cut down on the amount of work that ORS has to perform. Does that have any appeal to you?
I can't speak for the company. I don't think that issue has come up. I do know that the 12-month sequencing is a statutory provision, and I'm not sure how that would play out. But we have been lucky to live through a relatively stable economic time for the last 10 or 15 years, 20 years. That's not necessarily always been the case, and there have been periods where companies had to come in on an emergency basis to request rate changes because of the level of inflation and other changes going on in the economy. Obviously, the fuel clause proceedings have taken some of that off the table, but there's still a great deal of risk for overall economic trends such that a utility would be hard-pressed to say we can, as a general rule, stay out for 2 years. I think what you'll see is utilities rarely come in on an annual basis, but that is an important safety valve. And I think the credit rating agencies and the people who watch the utilities credits would find that to be somewhat troubling if that safety valve was taken away.
Well, how about this as a middle ground? What if you said that the investor-owned utility shall be prohibited from requesting a new rate case increase for 24 months, except for good cause shown? That way, if there was some emergency, you got the right to come in and justify your filing.
I understand. Well, my response would be if there's not good cause to file a rate case, you've got a problem to start with. You shouldn't be filing a rate case. So I'm not sure.
Just trying to find a solution.
I understand.
And it does concern me, you know, the fact that so much of your staff's time is taken up with research and answering requests for discovery. It really seems unfair. You don't have time to do your other work. And it places a tough burden on the Office of Regulatory staff as well. It would seem to me that a provision like that in a regulation, because a statute is a statute, and so we could just say, notwithstanding statutory provision, the commission would recommend or prefer that investor-owned utilities not file a new rate case any sooner than 24 months from the last application, except for good cause shown.
I understand. I don't know that I know that I can't agree to that on behalf of Dominion, but I'm happy to have Mr. Burgess take that back to the company.
It's just a suggestion. It seems like it would alleviate a lot of the concerns that you've raised today.
Well, it would help, but again, the companies are not filing annual rate cases today. They're filing on a multi-year cycle, and the problem still exists even on a multi-year cycle. It's not that it's compressing all the work that needs to be done for a rate case into such a short window.
Well, it does. And the last thing I'll say is I like your comment about the collaborative process. And maybe that's something that we could work in better to expand that collaborative process before an application is filed. See how much agreement can be reached, what issues can be resolved before the hearing is held. That would take, time as well. Would take staff time and add costs as well. So I'm not sure that's any better, but it does appeal to me that if you could continue the collaborative process throughout the calendar year, parties will have a better understanding of what's going on and what to expect, and perhaps be able to resolve some issues.
Understood.
In a collaborative way. Would you agree with that?
I would agree. Collaboration is the way that regulation is going today. There's no question. You see that across the board in other jurisdictions and here, and it seems to be bearing great fruit.
And the beauty of that is that it will have the win-win benefit of helping the company to work through these issues with ORS outside of a litigation setting, while at the same time saving costs the ratepayers would otherwise have to pay to litigate.
That's exactly right. And there will always be times when ORS and a company disagree, but the goal is that disagreement should not be based on a misunderstanding of the evidence or of the data or anything other than each party clearly understanding what the information is and taking a position based on it. So collaboration simplifies all manner of aspects of a rate proceeding.
And I think it also helps to build trust among the parties. We had a case this past year where there was a lot of collaboration and resulted in a stipulated settlement agreement, which I thought, was beneficial to all sides concerned. And, I'd like to see more of that happen, but you got to do a little bit of work on the front end as well. So just maybe I'm being too idealistic, but I think it could work if everybody would be committed to the process.
I share your idealism on that.
Thank you for your comments today.
And
that'll be my final comment. I want to thank all the parties for their participation today and sharing with us. You've made some excellent points and suggestions, and our staff's been taking notes, and I've been making some mental notes, so I really appreciate everybody's help. Thank you.
Thank you, Commissioner Urban. Further, Commissioner Caston?
Thank you, Madam Chair. Mr. Siegel, thank you. I didn't write down the number quickly enough that you gave earlier as far as man hours spent. Was that 5,400? What number did you?
The number was 5,780 to be exact. And
I assume they do that by however they do their billing and time track and keep up with their time.
I think they have what they call a work order related to those aspects of the rate case, and people put their time down against that.
Do you know how many staff are involved with a rate case?
You know, I tried to get that number, but it touches so many different people. It was very hard to get that because you'll have people who have one small thing that they have to do that, you know, maybe they spend an hour and a half tracking down a particular piece of information about a particular thing, and they show up in that number, and it seemed to me the number was overinflated by that sort of thing. So I didn't pay attention to that.
You know, I almost said something like, you know, that sounds a lot like attorneys, but I didn't want to say that way because I thought, you know, you keep up with all the time accurately, specifically, and that's a good thing. What I'm trying to better understand is, say, a utility the size of one I was familiar with didn't have that many folks, you know, 5,700, that's probably, it's just under, I don't know, 2.8 man years.
Mm-hmm.
2 people spending that much. But if it's 100 people, or if you got 200 people, you know, it changes. So I was just curious so I could kind of have a feel for what that meant.
Mm-hmm.
If there's 400 people that work on it, it might be just 200 hours scattered throughout the year. But we don't know that, correct?
Well, the core would be the rate department and certain of the accounting people, but no, I don't know exactly what the head count would be vis-a-vis that.
And is the company required to do an audit every year?
I believe that they are. I know that that there is an audit function that is constantly going around and checking on how well all the aspects of the company's accounting, including property management and whatnot, is taking place. And my understanding is that they're constantly checking on things, and that they have a specific set of ways of saying, here are the areas we have the most concern about, here are the ways that, you know, here are the areas that are, you know, on the list for this year for deep dive sort of thing. So yeah, they're constantly looking at that.
And I'm certainly sensitive to effort required because the cost to the company is passed on, and I get that. Right. I think we all understand that. And thinking back to my past, when we had to do different things, the accountant and different laws changed and all, and over the course of time, we adjusted, developed spreadsheets and stuff so that throughout the year, you know, we were constantly updating things that we were going to need for that process. And I was thinking relative to, say, these rate cases, say prior to any change that may or may not be proposed now, I'd assume the stuff's kind of the same. So I guess I would naturally assume that there's a process in place that you're kind of keeping tabs of that throughout the process, and it should not come as some big surprise and a lot of effort. And I don't mean to downplay it, but
right.
Does that make sense?
It makes sense, and I think what you may find interesting is that a lot of that keeping tabs is in what's called the quarterly surveillance report, which the companies file each quarter with you all, which goes through all the changes in rate base, costs, and the like. It lists all of the pro forma adjustments that have been approved or that are being that the company has. All of the components, in effect, of the rate case are put forward in there, and a return on equity is computed just the same way that you'd compute one in a rate case. So those are part of the constant updating. The 57 80 hours I was talking about is the stuff in addition to that that's required to actually pull together a rate filing because of the higher level of scrutiny and the additional documents that are required for doing that.
And these additional documents that are required or requested, are they, again, is it not something that is kind of going to be asked for every time?
It may be, but it may not be in that. I mean, some of it will, some of it won't. Every rate case is a little different. Some of them, I mean, there have been rate cases which have almost been entirely the result of a change in federal tax law. And that's a very different case from a case that's resulting because you just built a new coal plant or just built a new combined cycle plant, or some other change has happened in your system, or one that's there just because you haven't adjusted rates in 6 or 7 years. So the cases all have a different flavor and a different focus. And that's one of the reasons why the collaborative process is good, because you can take that into account as you go through. The company would sit down with ORS and say, here's what's driving the rate case. Here are the changes. And if you look at the applications that have been filed, they do a pretty good job of breaking those specific drivers of that rate case out in a way that we hope the commission can understand, so that when you pull the application up and look at the written thing, this much is a result of additional investment in the distribution and transmission system. This much is a result of X, Y, and Z. And much of what goes on in the background in terms of ordinary costs, if you will, standard costs, doesn't really rise to the level of driving a rate case. There may be some general inflation, but usually what you'll see there is it's well set out, and you can immediately target, here are the things that are causing rates to change. Let's be sure they make sense. And ORS is very good at picking all that out.
Well, I know you understand this, but you understand that we can't participate in that collaborative process. And I'm all for it. Get it? I think that is good. It's good when people can come together and work toward a common goal.
Yes.
No matter what.
And I understand that part of the commission's concern is that with the structure we have in South Carolina, there's not a lot of information that comes to you until testimony gets filed and you come into this room a month or two later and start hearing witnesses. And I know that puts you in a difficult situation. And the company's not insensitive to that fact. It's just we don't know that this is the way to fix it.
I understand. And I know that you also understand that I think our primary role is, rates, services, of regulated utilities. And I hear you, hear the utility, hear the concerns, and I don't think, speaking for me, can't speak for the whole commission, I don't think there's anyone that wants to place any undue burden or just more than necessary. But it's always that what is necessary and what is needed. So couple things and I'm through. I don't recall any of this. Do you recall what the last rate case expense cost for that?
I don't know off the top of my head. It was substantially, it's there in the document, I think.
Well, appreciate your feedback. Thank you very much. And no more questions, Madam Chair.
Thank you, Mr. Caston. Commissioner Caston. Commissioners, any further questions?
Madam Chair.
Commissioner Justin Williams.
Attorney Ziegler, thank you for your comments. I want to give a little bit of background for my question here today. Whenever there is 100% agreement on any issue, I usually get a little nervous because it's just hard for me to believe that there's 100% agreement on any issue. And so what I appreciate is that you offer a perspective that you disagree somewhat with the staff recommendations here, even though that you understand why they were made and you understand the position the commission is in. With that background, my question to you is, do you see the need for any change to the regulation?
Oh, I think apart from the minimum filing requirements and the 14-day and the immediate filing of testimony, the other changes and the ones we discussed are very sound, and I think they're good changes to the regulations. As far as the minimum filing requirements, I haven't been asked to go through and come up with an alternative set of minimum filing requirements. I personally think the 6 items that you have there are the high-level financial results for the company, and that's a very solid basis for an application. I think if you look at the information that the companies typically put forward in their rate case testimony, it goes through in detail many of the issues that I think the commission would want more information about. I just think that's a better place to put it than in a cold document filed at the beginning of the process. That the testimony and the hearing is a better place to ask the questions about performance, storm restoration, safety, those sorts of things. Not in a filing up front.
All right, thank you very much.
Commissioners, further questions?
Chair Belzer?
Commissioner Carolee Williams?
Thank you. I think my question really is for the entire room and might be for Director Boyd from a background perspective. It's fascinating and instructive to hear the different perspectives that we're hearing. You're all representing companies. Was the stakeholder process, did it involve the interveners that do not represent companies? I realize they've had an opportunity to comment, but could somebody speak to that?
Well, I think I'd have to look back at docket number 2020-247A. But the staff just issued notices of workshops and indicated which regulations we were reviewing at those workshops. Commissioner Williams, and anyone I think we asked for persons to let us know if they intended to participate. So it was open to the public. I can't recall right now. I mean, at one point during this process, we had a couple of workshops regarding our notices. And so AARP provided substantive comments, which were very helpful. I'm trying to think of who else. We just had a wide range of people. As it relates to, for example, in April, you'll have a hearing on our gas regulations. And so we had a very long hearing about a new proposed regulation regarding extensions of pipelines. I don't know how those persons found out about it other than we posted those notices in the docket. Okay. Yes, ma'am.
And I'm not asking out of any judgment associated with that, but it strikes me that the minimum filing requirements are there not just for us and ORS and the company, but all of the other participants. So that's kind of what
I do know that the the Department of Consumer Affairs participated and filed comments.
They did. They filed comments. As a matter of fact, when we initially started talking about Department of Consumer Affairs was kind enough to provide staff with different samples of minimum filing requirements in other jurisdictions, including Florida. Staff found their comments very helpful. So, yeah. So yes, ma'am. If whatever form, if you approve, if you decide as commissioners that you don't want to amend the current filing requirements, okay, then the public will continue to see what they've always seen. If you decide you want to add 4 or 5, delete 4 or 5, whatever you decide, those applications will still be available for the public on the docket management system, free of charge, 24 hours a day, 7 days a week.
Thank you for that humor at the end and the perspective. No further questions.
Commissioners? Ms. Gibbon for ORS.
Thank you, Madam Chair. ORS is primarily going to rely on its January 6, 2023 comments that were filed in this docket, in which we indicated our support for the minimum filing requirements. I would, however, just like to highlight 2 items for the benefit of the commission. The first pertains to the draft form schedules that were contemplated in the statement of reasonableness and need. Whether the commission decides to adopt those draft form schedules as put forward by commission staff through the regulatory process or through the utilities submitting templates and individual dockets for approval via commission order, ORS would like to reserve its right to review and comment on those form schedules. The second point relates to the filing of direct testimony by the utilities. ORS has been supportive and continues to support the filing of direct testimony by the utilities concurrently with the application. And I'd like to thank you for the opportunity to participate in today's workshop, and thank you to staff for their work in reviewing the commission's regulations.
Is that all?
Yes, unless y'all
Thank
have any
you.
questions.
Any questions for ORS? Thank you, Ms. Given.
Thank you, Madam Chair.
I don't see any, or is there anyone in the audience that had comments today? I mean, I think we don't really have anybody, but I think our point now is we leave the record will remain open for 5 days. I think not counting today, that will be next Tuesday, March the 7th. That if there are any additional comments that anyone would like to make with regard to the matters discussed this morning, please file on the DMS no later than March 7th. Am I counting right? Anybody? It says working days, so I'm
Yes,
not counting
ma'am,
the
you're right.
weekend. I think
Yes,
it's
sir.
working days, is it not?
You're right. I'm looking at the statute, Madam Chair. It does
Okay.
say no later than 5 working days after the hearing ends. You're
All
correct.
right. So we appreciate everyone's participation this morning and all through the process. I think I have to agree with the collaborative process for ferreting out as much as we can. We may not always reach agreement on everything, but I think it does help. At least it helps me understand what some of the various parties are facing when it comes to this. So we do appreciate your time, all the work that you've put into it. This has been a process that's going on for well over a year. And just want to thank all the parties for participation through the process and today. With that, we'll close this hearing, and I wish everybody a good day. Thank you.